moment.
Oh, okay.
We want to hear your tenure at
NPA.
Yeah.
I had an advantage, I believe, because when I went to the NPA, I already knew about it while I was DG Justice. I pretty much knew everything that was going on there, the good things.
Because you were the accounting officer.
Because I was the accounting officer.
Okay.
I knew the good things, I knew the bad things about it. So all the controversies around the NPA at the time, I already knew. I had the information. Also because I was chair of the cluster. So in the cluster, we would discuss all these things. So I already knew. The troubles that were there with the DSO, I already knew. In fact, when I was DG, one of the responsibilities post the cabinet decision was that the DSO must be disbanded. And I was tasked as DG naturally with the necessary putting in place of the legislation to disband. And the department prepared the legislation and it went to the National Assembly. It was passed and the DSO was disestablished on that basis. That was my job as DG to do, to follow instructions as they were given. So I was already...
During that time, were you involved in stuff, because there was DSO staff, movement of staff? To what extent were you involved?
Yes, yes, I was again very involved in that, because I think this establishment was around 2009. So when I moved to the NPA, it was still in that sort of transition process in Parliament. When Parliament passed the law, I think I was, at the time, I was acting NDPP. I was acting NDPP. So as soon as when I landed there, it fell in perfectly, because I remember one of the first things I did was, when I became NDPP, they came to pick me up in these jeeps that they had, some black jeeps, very popular jeeps that the Scorpion used to run around and chase after people. Jeeps, I think they're very special jeeps. They're called Jeeps Cherokee SRT, stands for Street Racing Technology. So if it's top of the range, I refused to get in there. I said, I'm not getting in this car, because I no longer have the authority to utilize it, because it belongs to the DSO. And in terms of the dissolution arrangement, the NPA no longer has investigative capacity. So I can't touch anything to do with investigation, because the NPA no longer has that. So the question was, okay, so what do we do now? Because this is the situation. A lot of files are here where they're stored in the NPA. There at VGM building, there's a place where they store stuff. Based on the stories I used to hear, I was afraid to go there. I never went there. But stuff was stored there. So I simply said, you know what? With all these cases that you guys were investigating, I think Dramat must handle them. So I went to see
Dramat was heading
DPCI.
DPCI.
Because when the DSO was disestablished, the police then had to establish the DPCI. But because the Department of Justice was at the core of disestablishment of the DSO, I was intricately involved in that, in the design of the DPCI. They drafted the legislation, but we had almost like regular joint teams to discuss what the DPCI should look like, because there were different advocates for different models. We favored a model where the DPCI head would be at the level of National Commissioner and would report directly to the Minister of Police. There were debates in the police, there was a pushback, and the argument that won the day was that, look, you can't do that because the Constitution makes provision for a single police service. If it's a single police service, there must be one head, so you can't create two. We thought about it, but we looked at it, we're like, okay, no, it's fine. It seems to make constitutional sense. So that's how the head of the DPCI becomes a DDG level person. So we removed in the structure, in the design, the head of the DPCI reporting directly to the minister, and we put him under under the National Commissioner. But their function, we designed it in such a way that we tried as much as possible to retain the architecture of the DSO, to say they shouldn't be really the same, because the intention originally behind the DSO was always to have a specialist kind of unit, as many would know, a la FBI or Scotland Yard and that type of thing. But it just didn't happen that way for a variety of reasons. So that's how we end up with the DPCI structured the way it is structured. So when I got to the NPA, it then had to inherit when Dramat was, General Dramat was appointed. So I just drove quickly because they were next door to him and said, no, Chief, I didn't say Chief really, but I said, you know, we have this situation. I've got all these files, I've got all these things that I need to handle. I don't have legal authority over these things. I'm dumping them with you, starting with these vehicles. So I just asked the guys, drop these vehicles here. So we left them there. So he accepted, he knew the situation. He said, okay, no, I'll deal with this thing. In the NPA, Willie Hofmeyer was one of the deputies.
But was that a proper handover process?
No, there was a handover process that was
because
proper.
the way you are sounding, Advocate Shamila,
No, okay,
you
understand.
just went to Dramat and dumped the cars and say the files are there. It sounds scary.
No, there was a proper process. No, I went to him. We arranged that the first order of business is that the vehicles we don't need. So, and he said, no, let them be dropped here, let them be parked here. We'll attend to them. So, in an orderly fashion, the officials of the NPA went and parked the vehicles over there. With respect to the files, we agreed that the DPCI must take over the files and that a designated person would be responsible for that. So in the NPA, I asked Mr. Hofmeyer, Willie Hofmeyer, to attend to that process. Why? Because it was natural. He had been there, he was head of the AFU, he knew all the guys that were in the DSO as many as possible, they were comfortable with him. And I just thought, coming from the department, having dissolved and dealt with all manner of things relating to the DSO, it's best if I step back from the process. And I said, Willie, please take care of this situation.
Willie Hofmeyer was one of the...
He was one of the deputies. He was my deputy at the time.
Okay.
So I said, please take care of this thing, all the files, you know everything, whatever needs to be done, it needs to comply with the law and therefore move over. With that, there were fights. Guys in the DSO, now where do we go? The point was, you choose. You decide where you want to go. You can go to the SIU if you want. You can go back to the police if you want. The conflict, not the conflict, some of the difficulties some of them were beginning to experience is that they were in the police first. That's how some of them ended up in the DSO. When they left the police to join the DSO, they were a junior in the police. In the DSO, they got promoted. Now, when they had to go back to the police, they had to go back at an equivalent rank. And they were immediately senior to most of their former colleagues by up to 2-3 ranks. And the police would have none of it. They were like, there's no way you're going to leave my junior and you're coming here, you are now my senior, and all of that. Anyway, it eventually got managed to say, look, there's nothing anybody can do, it must be done. Fortunately for me as NDPP, not my monkeys, not my circus. The police dealt with that matter on their own. The issue for me became those who wanted to go to the SIU, to say, look, we want to go to the SIU. And there were issues. Why you want to go to the SIU? Well, we're comfortable with this framework. So Willie Hofmeyer came to me and said, NDPP, what do we do in this situation? I said, let everybody make a choice and go wherever they want to go. Nobody must feel they've got nowhere to go. So because others were having difficulties in the police, the majority of the DSO guys went, well, not say the majority, almost 50-50 really. Others went to the police, others went back to the SIU. So that tradition carried through in the SIU. At the time, Willie Hofmeyer was in 2 positions. He was Deputy National Director responsible for the AFU, and he was the acting head of the SIU. So he attended to that, and then they also attended to the transfer of files. But what they tried to do, which I got resentful about, was they initially didn't want to transfer the files. They said to me, NDPP, please sign these prosecutions. And I said, what prosecutions? One of them was, I think it was Busasa. They said, no, we've been investigating Busasa. Can you sign off on this? So I refused.
Busasa?
Yes, Busasa.
Company?
Yeah, Busasa. I don't know what, I can't remember what it was before the name change.
Okay.
But there was something to do with it. So I said, no, I'm not signing anything. Why? We're ready. Please sign this thing. I said, no. Why? Because firstly, serious suspicion. You know, I knew the kind of things that the DSO was accused of doing from many quarters, in the sense that as DG, the executive authority received a lot of letters of complaints. I got sight of some of them, others I didn't, but there was a general complaint about the DSO. The nature of the process of removing the NDPP at the time was also quite a contentious and very unpleasant process for everybody, for a variety of reasons. Within the cluster, the issues that we discussed there of a national security nature, to to the extent that we could discuss them over there. Others would discuss them in a closed forum under the National Security Council of DGs. Really unpleasant thing. So when somebody or some people come and say, please sign off on this prosecution, I was like, I'm not signing. These were memos and so forth. So I simply said...
Let me just ask something
Yeah.
and clarify. When you say that you wouldn't sign on the basis of what was being said, wouldn't the responsibility be to sign on the basis of the docket and the merit of the case? Would you have looked at the case itself rather than what everybody is saying, the JCPS? Because, I mean, if you come to us, even today, if anyone asks me about a case, I'll have a view. But I don't know the content of the docket.
Yeah.
Now, the NDPP would have to make a base decision on the basis of information inside the file.
Yes.
Now, I get worried the way you are classifying your reasons for this.
No, that's correct. No, that's correctly that. Because when I then asked questions, well, it was the manner in which it was being done as well, in the sense that, there's no formal meetings being set to say, look, let's meet and discuss and look at all these types of things. It's talk as we attend to other things. You need to sign off on this or sign off on this. So I simply said, I'll gladly sign. One problem. These matters are not ready for prosecution. You guys are still investigating. Yes, we are still investigating. So I said, well, on that basis, I can't sign anything that is not going to start a prosecution. These are matters that are still under investigation. You're not finished. I don't know how far you are from being finished. So I don't have authority over investigations because the NPA no longer has investigative capacity. So please take these to Mr. Dramat. Well, I didn't have them with me. They didn't give them to me. They just mentioned them by name. I said, please take all of those files, take them to Mr. Dramat with all the trunk. I can't remember what those things are. That's where the stuff, documents, things were. I said, no, take them to Dramat's. They'll attend to them as a DPCI.
Maybe let me re-ask the question. So are you saying at that time where these files were brought to you, you had this inclination or you believed that these colleagues were disingenuous, were not genuine, were acting rationally?
Correct.
By bringing this because they had not done, and they were rushing to bring it to you so that the files don't go to the other side?
Correct.
Which shouldn't have been, and that's the basis.
Correct.
Is that what you are saying to
Correct.
us?
Yes, I was very suspicious of that.
So they were
particular
dishonest
process.
in their conduct? Because if they've done that, that's dishonesty.
Well, I'm going to be very careful about my wording because last time some suggestion of that nature was made, I said, yes, I got into big trouble.
Oh,
Let me put it this way. We'll deal with it, Minister. The issue was, can I go a step back? Let me go a step back. What was the problem with the DSO? The problem was simply this. The legislation of the DSO gave the DSO intelligence capacity. So they had a mandate to gather intelligence. The problem operationally is that there were then multiple agencies in the country that gathered intelligence. And on the ground, they couldn't work very well together. There were various suspicions for a number of reasons, mostly historical, pre-1994. People on this side knew people on this side. They didn't trust each other. So all those legacy issues found expression in the actual work of these institutions. And because of that, it was so bad and so difficult that in one incident at the airport, we got a report as the cluster that the DSO and the police agents who were undercover following some suspects almost shot at each other because they didn't recognize each other, that they're after the same target. And the question was, but once you're talking, why are you after the same people and not know about it? No, it's because these guys work with this way, these guys work this way. So it became ugly. It got to the point where the president at the time appointed the Khampepe Judicial Commission of Inquiry to look into the manner in which the DSO was dealing with intelligence issues, because it had reached a point where arguments were made that there is a national security problem because of these kinds of issues. Those who were closest to those issues, I didn't. Those who were closer to those issues, it was NIA at the time, together with the Secret Service. There were still two at the time before they were amalgamated and they've now been separated. Those two DGs there raised these issues with the crime intelligence and the police. DI got involved in it. But that whole mechanism of trying to explain to the executive what kind of problems were there with these kinds of duplications led to that point. So again, as the Department of Justice, we took responsibility for supporting the Commission of Inquiry. My officials provided that. The minister was responsible, obviously, to make sure that the commission functions properly, attended to her responsibilities accordingly. And evidence was led and all sorts of things. And the Khambebe Commission reports came with an acknowledgement that indeed there is an unsatisfactory manner in which intelligence information was being handled by the DSO. And primarily, some of the allegations were that they were infiltrated by foreign intelligence and they were continuing to work in an unauthorized fashion, or at least in a way that it wasn't through protocols as intelligence environment would require. They were doing these things on their own. Their argument was, read our law, we have a mandate, we could work, amongst other arguments. The long and short of it is that by the time I went to the NPA, I was aware of all of these things and the fact that some of the people complained about were in the NPA and how they were managing things. So by the time Vili and some of his staff made these suggestions, so they didn't bring the files like this, Minister. We're just talking to say NDPP, there are files, they're over there, you can see them if you want to see them. They need to be signed off on for prosecution. So for me, I was like, no, red flag, based on what I knew. But the cleanest way of dealing with it and to say is that, you know what, they're just not ready for prosecution anyway. So let them go to, and that's how they moved over to the other side.
I think Mr. Mtlung has got a follow-up on this matter.
Thank you, Minister. Advocate Shamila, I just, on riding on the question by the Minister.
Yeah.
And it appears that you relied on a verbal report in terms of a request to sign off. Wouldn't it have been prudent of you to seek or to request the docket or any documentation just to satisfy yourself? I understand the issues around mistrust and so on and so forth. But as the head, wouldn't you have perhaps insisted on satisfying yourself, particularly take into account that you considered the process, or rather the investigations to still be ongoing? The investigation was still ongoing at the time, according to the report, the verbal report.
Yeah.
But you did not satisfy yourself.
Yeah.
Was it not prudent of you to actually go further and obtain all the necessary information to satisfy yourself that the decision that you were making was the correct decision?
It was the correct decision. It became unnecessary to even go that route for the simple reason that to the extent that matters were still under investigation, the NDPP has no investigative authority by law. The NPA has no investigative authority by law. There's nothing further for the NPA to investigate in a docket in the manner that those matters still needed to be attended to. So those matters were matters that were supposed to be handed over in a formal handover to the DPCI for further investigation. It didn't even become necessary to even go that route. In fact, it would have been improper to even go that route, because what authority would I have been exercising in law? These are open dockets under investigation. What would they be doing with the NDPP? What law would you be using to look into them? So these were just unfinished matters. They needed to go. That's why for me, even the suggestion that I look into them was annoying. Like, no, I can't. I mean, what do you think I am? So that's how we did it. So that became unnecessary. So I asked Mr. Hofmeyer to just attend to the necessary and do the handover. I delegated the process to him. So he attended to that in the normal course.
Was it the head of DSO who said you must look at the file, or was this investigators?
No, it was Mr. Hofmeyer.
It was Mr. Hofmeyer.
Yeah, he was handling the process for me.
So he was handling that, and then he says, no, I've got this file.
Yes.
I need you to sign.
Not this file. We've got these unfinished matters
Okay.
Yes, they were in boxes or in trunks stored somewhere. They didn't bring them to me, but you wanted to say some of them need to be looked at and you may need to sign some of them. So when I asked, okay, what would need to be signed, what's happening, what's the progress, these are matters that are under investigation. And
So not like prison, so all of you didn't go file by file?
No.
Because ordinarily you'll have to go through the file and say, this is file so-and-so, like Bosasa. How did you know the Bosasa one?
They mentioned it.
They mentioned,
Yeah, they mentioned
to say
by
one
name.
of them is this.
Yes, they mentioned
and
by
then
name.
amongst others.
Yes, they mentioned
And
by
that
name.
one they were saying they are ready to go, please sign.
Yes.
And you said, no, I can't sign.
Yes, because the patent,
You are
when you ask a few questions, they say, no, we're still investigating, we still have to do that. Like,
Oh,
so
okay.
why are you asking?
So
You
it
know?
was on the conversation that
Yeah, it
you
was on the
started to say,
conversation.
okay, you want me to go and get those files. Therefore, but are you done with your work? And then they say, no, we're not
No,
done.
we're not done, yes.
We were still investigating.
Yes, precisely.
Okay.
Then I said, no, then if that's where you still are, then we shouldn't even be having the conversation.
Okay.
So in essence, then, Minister, that experience, I take it that the part about the removal of the NDPP, the general inquiry, want to deal with later, because that was when I was DG. I know it came up in the objections. I don't know if you want me to deal with it now. Or... Okay, no, that's fine. Segment. No, that's fine. Okay.
Sorry. My apologies. We're looking at your tenure now.
Yes.
As the NDPP.
Yes.
Compared to all the other candidates, you're the only one who has been
Okay.
even at that. So others will look at them from where they've been in the NPA and their role. So we want you to tell us, why must you come back?
Okay.
You've been the NDPP, what is it that you have done? So your career that time, your tenure that time.
All right. When I got there, as I said, I already had a pretty decent idea about what's going on in there. One thing that which one am I going to start? You get there are deputies, and then you have one deputy in charge of NPS, National Prosecuting Service, one in charge of AFU, one in charge of this. So
You had three deputies. The law allows for 4 maximum.
I think I had 3 at the time. I don't remember 100%, Minister,
Okay.
but it was AFU, it was
AFU,
NPS,
NPS.
it was Dr. Ramaite was there. I can't remember what you were responsible for. Yeah, there may have been 3 at the time.
You found them there.
I
You
found
were
them there.
one, and then you got appointed.
Yes, then I got appointed, yes.
And then you replaced yourself. Did you eventually get
Yes,
replaced
if you want to put it that way, yes.
in the 2 years?
Yes, indeed.
Okay.
That was the order of things. So when the issue was like, okay, most senior staff, so I need to have a meeting. So I was told, no, you're going to meet here, the deputies, and that's the exco of the NPA. So we had our first meeting, but I looked at it as like, okay, so where are the DPPs? They said, no, DPPs are not part of exco. They answer to the deputy in charge of the NPS, and you get your briefings via the deputy head of the NPS. So I looked at that with a squint and I said, I don't quite understand this, because I didn't understand the law to be this way. I said, if you look at the Act, my understanding is that the DPPs are the ones in charge of their areas of jurisdiction. That's what I know. So, and they are the ones who institute proceedings to prosecute or not. The NDPP has the power, but hardly does. It's very rare. But the law authorizes the DPP. So why would they not be here? They said, no, the NPS head does it. And I said, no, to me this feels a bit uncomfortable in the sense that structurally it just doesn't feel right that people who are responsible, with primary responsible for taking initial decisions, and that as the NDPP I have authority over, I should hear from them via a third party. So I said, look, it's fine, I don't have a big problem, but I'd like to change the arrangement. From now on, the exco of the NPA would be the NDPP, supported by the deputies, and all the DPPs. They must come to exco and explain how they function in their areas of jurisdiction. Deputies didn't have a fundamental problem with it. There's a bit of uncomfortableness in it. I said, we'll all see the benefits of it. So the first exco with the DPPs present went very well, and everybody was happy. The principle was, You are in charge of a jurisdiction. It's what we called it was, it's a federation kind of environment. You do by law what you're empowered to do. That's your business. I'm not too interested in it. But you come here and you account for whatever you have done or not done. So I expect you to brief me directly. Then I realized that there were no performance agreements, because the question was, okay, how do these people report? So I insisted right there and then. I asked one of the SPPs who was assisting me to say, please take the performance agreements of my former DDGs in the department, have a look at them, and create for me a performance agreement that I can have with the deputies and the DPPs, because I need to find a way of managing it. So that's how I introduced performance agreements at that level in that environment. Then I turned to other things. I think I've got here some of the stuff that I did. What I then found as well was that there were a lot of legal issues that came to the NDPP. And I asked around to say, who handled these things, process them before I see them? Because they were coming directly from various offices and the PA and that type of thing. And it became a bit unclear. So I established what is called LAD, which is the Legal Affairs Division. I said, no, but I need some lawyers. Let me get a few guys from within who are legally qualified. Can I form a small unit to be Legal Affairs Division? And I got me Advocate Khanyile, who was there at the time, to basically, was the most senior, was an elderly gentleman, to go on retirement. I said, because he's an elder, can he just supervise these youngsters and be in charge of LAD? Basically, their job was to get all material that is distinct for the NDPP, have a look at it, and advise from time to time on legal issues. So I established that unit. It exists. I think now it's headed by Special Director, Mr. Advocate Maga. Then, as part of the discussions, one would then get informed, obviously, of a number of complaints about typical labor relations complaints and complaints about officials. And I got to learn that there was a unit called the Integrity Management Unit that was tasked with investigating NPA staff generally for any alleged transgression. So one looked at it, and I got to learn that there'd also been discussions about how that can be improved. So I looked at the Act, and I realized that there's actually a provision in the Act for kind of like an inspectorate, a body that would investigate the conduct of prosecutors. I think it's, I think I provided these documents, if I can just remind myself quickly. It's a complaints mechanism that would be established. It's provided for in terms of, I think it's section 22.
Is it the Office of Ethics and Accountability?
That's what they call it now, but at the time, we were calling it a complaints mechanism. You know,
okay.
We're still initial stages of creating it. I don't know how it currently functions, but the IMU minister would investigate anything, like in any department with an internal investigative division. That's what it would do. So this one dealt with everything. But what Section 22 of the NPA Act envisages in mind, has in mind, is a different kind of body. If a prosecutor commits misconduct in the course of prosecution, who should investigate that prosecutor? At the time, in the NPA, it was the IMU, the Integrity Management Unit. But if you look at the legislation, it suggests something different. So what you have is that you have officials in the IMU who may be labor specialists or specialists in something else, effectively investigating the conduct of a prosecutor. So basically, they're investigating the conduct they don't understand. That, for me, was a problem. You can't investigate a function you don't understand because you're not qualified, you're not a prosecutor, but you're investigating whether or not a prosecutor acted properly or not. So the Motoso case, for example, would have been a case to be investigated by another prosecutor to assess on a peer-to-peer basis whether the matter was handled correctly or not. if it is not investigated by that kind of person, you are not going to get an accurate account of whether something wrong happened, because all you're going to get is somebody who doesn't have the same appreciation of the issues, doesn't understand how a prosecutor thinks. So if you are to be asked the question, what made you not call this witness? A labor relations practitioner would hardly have a clue how a prosecutor would have exercised a discretion to not call a witness or rely on this evidence or that evidence. Only a fellow prosecutor or lawyer at least would be in a position to ask the right kind of questions. So this is what I was then pushing for, to say, no, we need a complaints mechanism. And the document I provided were the initial stages of a consultant report towards what that complaints mechanism body would look like. So by the time I left, we hadn't quite yet finished with it. But we had engaged on some drafts, and I'd already indicated to the minister at the time that something of that nature was coming up. So that's that. And then as you work, you go and you meet units, specialized units were there. One of the things that also was brought to me, to my attention, obviously I knew about it, was the work of, continued work of the specialized unit. So one of the things I asked was, let's start with the SCCU. Who's in the SCCU here at HQ? And I was told there was a special director. I'm not, if you don't mind, Minister, I'm not going to name his name. He left the NPA. He's there. If I recall correctly, there was Advocate Blatenbach, Glennis, and there was somebody else. So it was like 3 people or 4 people or so. So like, okay, what do they do here? And like, no, they handle SCCU cases. It's like, okay, what are they doing that for here? Because the SCCU, as I know it, is in the areas of jurisdiction of the DPPs. In Pretoria, Advocate Mzinyati had his SCCU unit. There's an advocate there who's in charge of it in Joburg. There's another deputy director in charge of the SCCU in Joburg. So what is this SCCU doing here? What kind of cases are they involved with? Well, they call it cases, they have a look at them, and decisions to prosecute are made here, but they work very closely with these officers. So for me, I became uncomfortable with that approach, because like, okay, if you're here and you take decisions to prosecute here, what happens to the DPP? Does the DPP know about it? So yes, we engage, we know, we discuss. Long and short of it, I'm uncomfortable with it, I don't like it. If there's going to be dockets taken from heads of SCCUs for whatever reason, whether for thorough check or whatever the case may be, and they come to headquarters, which is basically my office, the NDPP office, and out of that check, a decision to prosecute gets made there, then I'm not going to have it, because what it means is that my office and me basically is making a decision to prosecute. And the problem I would have with that is that you're excluding the DPPs from that decision, even if you talk to them. They are the ones who should run these particular matters, make decisions. My powers will largely be review powers in terms of 179. So I'm feeling uncomfortable. It said, no, this is how it's always been done. It's not a particular, it's not an issue really. The DPPs really know. I said, I don't understand, I don't have a problem with it. I get it. I just don't like it, and I don't want it. So my suggestion is that these measures that are here, there are not so many as well. I said, please take them back to the relevant jurisdictions. But if you want to work on them, you could stay. But if you want to work on them, then I suggest you go and work on them in the relevant jurisdiction. So you can go to Pretoria under Mr. Mzinyati, or you can go to Gauteng under Advocate Khanyile, acting DPP. So
maybe just to ask there as well, was there a review that you had done to evaluate the work of this team to see if, based on head office, they are there doing the work they've done, obviously, before you arrived, some work where you presented with like a review to say this is what, so that when you almost implement restructuring, which you're saying that they must go to the provinces, therefore you would have seen that it has value. What was the basis of that conclusion?
The basis was purely legal. It was purely legal to say, in the past there may have been decisions taken, but in my time, I would not want to be the one taking a decision. So if my predecessors were comfortable with it, that's also okay. I don't have a problem with it. But I have a difficulty with it because I see a legal problem, at least coming up in the sense that, firstly, one, I would be undermining, or I'd be appearing to be undermining the DPP's consent. And most of the cases were largely Joburg and Pretoria. There may have been one or two from other jurisdictions. So I don't want that. Let them handle the cases and deal with them themselves.
But when you say legal, Advocate Shamila, are you saying, because legal, you are giving an impression that your predecessors would have taken illegal decisions by having those. There was nothing in the Act or in law that did not allow for that. You just felt uncomfortable to have it. Am I correct?
Well,
but in law, legally, there was nothing precluding the national office to have such an arrangement, to have that team operating.
I wouldn't say in law there would necessarily be nothing preventing them, because I know that the national director can institute prosecutions. But what that informed me about was that these were cases that basically collected as part of monitoring the SCCU units. They would monitor the statistics, all of that stuff, and then when they see in the statistics and in the reports a matter that they felt it's necessary to have a further look at, they then ask for the information and the docket and they have a look at it. So my argument was, well, when you do that, you can't either take decisions here of a prosecutorial nature, let those matters go back to the offices that were responsible for them. And I did have discussions, informal discussions in the offices, and everybody understood that to be, that's just how things are. There's no issue. Then when I said, well, I wouldn't like this, Ms. Khanyile, Mr. Mzinyati, I'm going to have these matters sent back with the people that want to handle them, if these guys were handling them. If they don't want to handle them, you'll then reassign them, and I'll see what I do with them at HQ. That's effectively.
So you disestablished it at that time? Because we do have Khanyile heading the SS.
No. Khanyile was the acting DPP in South Gauteng.
No, I'm saying now it's Khanyile. It's SDPP. Special Director, Public Prosecution.
Ms. Khanyile was there. She remained in my office.
No, I'm saying you disestablished. I'm just saying currently, this unit is back into national.
Yes,
it's also existing.
After I left, they reversed my decision. My decision was reversed.
That's the context I was saying to you. There's nothing illegal about it being in national. Because before you, it was there. You felt uncomfortable and said it must go to the provinces.
Yes.
After you left, it was brought back.
Yeah. There's nothing illegal in that. You can have it there to analyze statistics, because you get all manner of information. There's analysis, there's strategy information, you analyze, and if you're specializing in analyzing SCCU information, that was never a problem. I said, I don't have a problem with it. Where the problem comes in is when you're then going to have a docket that you're going to be looking at and investigating and deciding on the docket here. But if you're analyzing information, it's no different to analyzing normal prosecutorial statistics for purposes of informing strategy, planning, measuring performance, as the case may be. So that wasn't a problem. All that moved were the actual dockets that were there at the time. Yeah. So I did the same thing with soccer to say, to the extent that there's a sexual offences unit where prosecutors were there for purposes of taking decisions on prosecutions that were in the Thuthuzela care centres. I said, you shouldn't be here at HQ. You should work in a Thuthuzela care centre and take decisions there. Here, you can sit and analyze information and do all of those kind of things. So what I then did was I put together a memorandum, submitted it to the minister with a recommendation that this be done, because only those kind of things can be approved by the minister, at least as a final decision. I submitted that, and there was an approval, and it was implemented. Yes, there were people who were unhappy with it. There were, in fact, the special director at the time said to me, well, I'm here, what am I going to do? I analyze. If you're saying I must go to the DPP office and run a prosecution, I haven't done that in a couple of years. I'm happy doing analysis. My argument was, I don't have a problem. You can be around as long as you don't take decisions to prosecute. Also, don't have a problem. You can pick and choose where you want to go and work. I really don't mind. That is not the issue for me. The issue is I want to be protected so that as the NDPP, when I have to make decisions to review when representations are made, I don't want to be put in a situation where I can't do that because an earlier decision had been taken in my office or had been taken with my knowledge. Because if I did that, the way I saw it, if I was part of taking that prosecutorial decision or it was taken under my authority in my office, and then a party put representations to the DPP and escalated them to the NDPP, I'll then be functus officio because I would have been part of the initial decision-making. So my view was that let me protect myself from this and take a step back and allow the DPPs to work. And part of the reason was that when I engaged with DPPs, as we did in EXCO, I learned that they had been uncomfortable with not being part of EXCO, that they were uncomfortable. They were more comfortable that they were part of the executive committee and reporting directly to the NDPP themselves. They were always uncomfortable reporting to somebody else who would speak on their behalf to the NDPP. They felt that they could do that better themselves as the primary people responsible. So it resolved itself in that sense. But I was able to manage the relations between the officials. Fortunately, they were all really good people. There was no issue at all. The matter resolved itself in that way. So that's what I did at that particular time. Then there were a couple of cases that we handled. Handled in the sense that the nature of my relationship with the DPPs, Minister, was that you do as you please. It's your job, it's your power. All I do is hold you accountable. There's a performance agreement. If there's a complaint about you, that's where I come in. But you take all the decisions. There are certain matters that are referred to as high profile for whatever reason. I never understood why. It didn't really matter to me. But you make those decisions. But if you want my support, it's in your interest to keep me informed and briefed so that I know what you're talking about. And if the NDPP were asked, I need to be able to also respond and give the most accurate information. You exercise, I either refer the people to yourselves to talk to the issues, or if you want my support with whatever decision you make, it's better we have a relationship where we brief each other more often. More often as in more than the scheduled briefings of EXCO meetings once a month. So some DPPs took that up. Others really didn't. It didn't matter. It didn't affect our working relationship. As part of that work, let me just find these cases that I mentioned so that I deal with them. What I used to do, the question then was, okay, what does an NDPP do if you're sitting in your office and the DPPs are doing all this work by themselves? So I had to think about what the best way would be for me to not only keep myself busy, but try and identify things that would be critical to attend to. Now, I'm just trying to get my files, if I can have your indulgence quickly. So what I would do in the mornings, I would read the newspaper. I read the newspaper, and then I finish reading the newspaper, pick up something that comes up that would be of interest, and follow up with the DPP office.
Okay.
One of the matters that was in the front page of the Sowetan one day was a matter of, over the weekend, some young people had allegedly been drunk and allegedly had taken some drugs, and they decided to race cars in Soweto. And during that process, they, because of their condition, they ran over some pedestrians. I think one or two, if not at least one, pedestrian died as a result. Another was paralyzed. So I took that and I immediately called...
Is it the Jub case?
Yes, the Jub case. I immediately called the acting DPP in Joburg. I said, have you seen this newspaper? She had it and said, okay, let me just get it quickly. And she got it, says, yeah, I see it. I said, this is a problem. This is interesting in the sense that the way this thing happened, how can you drag race in Soweto? I can't imagine what street it would have been in Soweto. I'm not a Sowetan person, but I've been in Soweto. So I was trying to imagine where they could have done this. So I requested, I said, no, Oli, can you send a prosecutor there, find out which courts these guys would be appearing in? And let's find out what happened and let's talk about this, because for me, this is murder. We should have this as murder. She said, murder, really? Okay, no, it's fine. Let me go have a look and then we'll discuss. So...
You were having a discussion with who on this matter?
The acting DPP in
Okay.
Gauteng. So she went to speak to prosecutors following their process. And then we started having a discussion about it. And the question was, no, but, it's not going to be murder because generally in drunken driving, we charge with culpable homicide. I said, I'm not so sure. We had a long debate about culpable homicide. I said, no, I'm not so sure. I'm not convinced. If what is reported is correct, that the individuals drag raced, it means they must have had a conversation about racing. And if they had a conversation about racing, it means the race was intended. It was intentional. It was an intentional decision to race from one area of Soweto to another area of Soweto. So for me, that is intention. Why would you say it's just cup? So I said, well, it's never happened this way. It's difficult. So I said, you know what? Perfect to do a test case. Let's do a test case with this. Let's charge them with murder as a first charge, so that if we fail on murder, we get a competent verdict of culpable homicide instead. Because if you charge with murder first, or culpable homicide first, and you don't succeed for whatever reason, you have problems. So we discussed, and we're like, okay, let's do a test case, because all the elements were there. It's the kind of case in law, if you want to test the law and have a test case, the general rule is that you must find the best facts for that to do. You don't use difficult facts because it doesn't work very well. Find the perfect set of facts, and then you can go and test your theory in courts.
At this point, Advocate Simelane, you are having this discussion on the basis of a Sowetan report.
No.
Not what
this was now a couple of days later, because
Okay.
there had been further engagement between the prosecutor dealing with the case with the police and all of that stuff, getting information, statements from people. But
Yeah,
the
because you didn't mention that. That's why I'm worried.
Okay. No, I understand.
Because you're saying you saw a headline on Sunday. You called the acting DPP to say this thing, these people, if they drag race, as the report of the Sowetan says, therefore it means it could be. And that's why I'm worried about that basis.
Oh, yes. No, I understand. No, this was a couple of days later as I was getting more information about what happened, number of people involved, who the individuals were, where they were coming from, what is suspected is the drugs that they're taking at the time. But the principle about how we would consider approaching the case, yes, I'd looked at this Sowetan to say, based on what is reported here, I think we can start looking at this principle. But when all of that was done and the information was ready and docket was ready, we then tested to say, please have a look at this and have a look at it and let me know if it is indeed the kind of case where we could have this test case. So they looked and said, no, actually we can. There was additional information subsequent to that they obtained, eyewitness accounts, some of the people and the friends who were there. Their account of information strongly suggested that there was an element of boasting between the parties about who drives better, who can race better, and all of that stuff. So it fitted the elements. So the conclusion was, okay, we'll try it and use a test case for this purpose. And it went, and fortunately the conviction went very well, and the rest is history vis-a-vis those individuals.
I want to move on from this segment. You still have something that you want to say?
Okay, let me be quick. I then dealt with because there's 1, 2, 3, 4, 5, 6 cases that I specifically was involved in that may be worthy of mention. Then the second case was what was referred to, I can't remember the name of this case, but State versus somebody else, but it was referred to in the media as the Naomi Campbell Diamond case. If you remember that. The issue about it was that somebody had been given by the supermodel Naomi Campbell a diamond, and it was alleged that Naomi Campbell or somebody had obtained this diamond from Charles Taylor in Liberia and so forth. It became a public ugly thing. Now, the interesting in this case is that, well, it was in court. Then it was going to run, and I received representations. I received a call from the late Advocate George Bezos. He said, Menzi, we knew each other. He knew me. He knew my dad, and he knew me. He said, Menzi, I need to see you about this case. I act for this individual. And I said, no problem, Mr. Bezos. Whenever you're ready. He said, I'll come to you. He came.
So he made direct representation to you without the DPP?
Yes, he came direct, yes, without the
Shouldn't
DPP.
they have gone to the DPP?
Yes, well, they would have. I think they did, in fact, go to the DPP, but he first wanted to speak to me about the case to let me know that this is involved in this case. I said,
So before meeting the Advocate Bezos, did you ask for a report or meet with the DPP to understand?
No,
Because my understanding of the process is that representation will be done with the DPP. You will be the reviewing process, isn't it? If the decision by the DPP is asked for you. So in this case, you are saying to us, Advocate Bezos comes to you directly, having not gone to the DPP.
Correct.
To afford the DPP a decision-making process which is allowed by law.
Yes. He was not asking to make representations. He was asking to see me about the case. So almost like a meeting, but not really a representation. So I said, no problem, we can come through. Then I arranged for one of the...
In the middle of a case, which you could have powers to review, Advocate Shamila.
No. For now, I was just asking for a meeting. So the question was, okay, I hear you're representing this individual. We can meet. So for me, I was curious to say, okay, what does he want to say? Let me hear him out.
You were aware that he's representing an individual
he said so.
On a case that is before court.
Yes.
And your DPP has not come to you to say we want to engage. What was the basis of you agreeing to that meeting?
Yes, I did inform the DPP that there's going to be a discussion. I'm going to meet Mr. Bezos. For now, it's just to hear what he has to say, because I don't know what he's going to say. The matter wasn't running in court yet. It hadn't started running in court. I think there was an appearance already, and I think the gentleman was given bail or something like that.
The case was before a DPP who had made a decision to prosecute.
Yes.
But don't you think that is irregular?
No, it's not irregular, Minister. What I then did was I then asked the prosecutor...
You know why? Let me finish.
Okay.
You just said to us, you decided to remove the soccer. You decided to, because you felt that you didn't want to undermine your DPPs.
Yes.
You wanted to ensure that the powers of prosecutorial decisions are with the DPPs, not with the NDPP. So if the dockets are sitting with you at National, it would have meant that you are undermining your DPPs. Therefore, you wanted the dockets to go to the provinces, to the DPPs, for them to make a decision. Now, in this case, the docket is with the DPP. A representative of an accused is requesting to come and see you while the case is being dealt with by your DPP. Isn't that not an undermining of your DPP, which you intentionally, when you arrived, felt that you needed to give them powers? Was it not counterproductive for what you were doing and what you saw as a vision of your tenure?
Not at all. This was purely going to be a meeting to say, okay, we are going to meet. What do you want to discuss? What are the issues? What I then asked for from the DPP was the prosecutor who was dealing with the matter to say, because there's somebody who's dealing with the matter, can somebody be here so that also I'm not alone? So I want somebody to be here with me so that we have this particular meeting, which did happen. So there was a prosecutor there who came, and Mr. Bezos said, are you going to proceed with the prosecution, because we are going to be making representations about it. So I said, no, it's fine, you can make representations. What is the issue of concern? Then what he indicated was, well, you know, for us, we would argue that this matter should not be prosecuted. Then we debate, why should it not be prosecuted? He made arguments to suggest that it's de minimis, you know, we're going to be making.
At the stage, you are now engaging representation.
Yeah, he's starting to, yes, you know, he did. He's starting to say, well, this is, we think it's de minimis. So I said, well, I don't think it's de minimis, and I don't agree with that. My suggestion is that we're going to proceed, you guys will do whatever you want to do and make the representations. Then he left on that basis.
I've got colleagues who wants to follow up. Prof, and then Advocate, the two colleagues.
Thank you, Chairperson. Advocate Simelane, you invoked something when you were making changes to your office that you wanted a federal type of arrangement.
Yes.
Which expressly would mean you give your deputies direct power. So by accepting this invitation to meet from, Judge Bezos, was it out of respect or was it out of what? Because surely, when you already know that the case is being handled and he'll be representing the other side, you would have known through your judgment that there's no way the person is going to just come, sit, and you chat around this particular case. Because this seemed to be counterintuitive to the very logic you introduced when you were making changes.
No, I don't share that opinion. I don't share that view. As NDPP, I met a lot of people who would ask for meetings about many things. Others would want to just share their views. My condition was, of course, not a problem if you want to meet. Obviously, one would create the appropriate framework for it. In this case, I'd made the DPP know that there was going to be this decision, and the prosecutor involved, can he be there so that we can listen to what is being said, and then we'll find out what is being said and then take it from there. So indeed, it was partly out of respect, but he's not the only one with whom I've met with prosecutors. But it was really to hear what the issue would be. So beforehand, I didn't know, but when he came, he said, well, this is what they would argue in their representations. Then I said, no, it's fine, then I'll deal with those when they come, but I'm not inclined to not want to have the matter go ahead. And then the meeting ended on that basis.
Thanks, Minister. Good afternoon, Advocate Shamila. With all things considered, me and you would know as part of the other lawyers in the room that there's a good reason why we create a rule. And the reason we create a rule, we would expect it also to be followed, probably hierarchically by everyone. Your expectation when you were at NPA would have been that a public prosecutor at a district court would not willy-nilly accept representations without the participation of the SPP or at least your DPPs in the provinces until either the decision is then reviewed by yourself. And that's a rule you made. Wouldn't you have been comfortable that nobody would have gone against that rule?
Would I not have been comfortable if?
Would you have been comfortable, rather put differently, if anybody went against that rule? Say, for instance, somebody started with the DPP and went back to the prosecutor down there without that prosecutor and the SPP having had an opportunity to make the decision on the prosecutorial nature of the matter that is before them.
No, in the sense that on the ground, people would speak to anybody. Representations are made formally,
Yes.
generally, right?
True.
So when they're made formally, they follow the process.
Yes.
But outside of formal representations, people want to meet to explore attitudes. Sometimes they would say, look, we just want to explore an attitude. We want to consider raising this issue or that issue or that issue. This was that kind of meeting to gauge what your attitude would be to issues that we would want to raise. So come and raise those issues. But it's not the formal representations, because remember, the formal representations, more often than not, they are written. So this was not a case where there were written representations that needed to come.
No, it's fine, Advocate Shamila. I'm making a simple point of a simple principle of a rule. And I want you to take us into your confidence that in receiving this meeting request from Advocate Bezos, as he then was in his lifetime, you were not creating an opportunity to be clouded. Because at the time that Bezos calls you, it's not that the case is not yet in court. There has already been an appearance. He tells you even over the phone, I want to see you, I'm representing this person. From that moment, doesn't it occur to you that then Bezos is using proximity to you in order to get this possible added advantage? Does it not occur to you at the time? And I'm just looking at it, colleague, from a point of hindsight. No. I mean, you took the decision at the time. You can't undo it now. So reasoning it may not need to be on the basis of, do I think I was wrong? And that's how I'm looking at it.
No. On the principle of the rule, you are correct. But no, I didn't see it that way.
No, that's fine.
I spoke to the DPP.
No, that's fine. Thanks.
Mr. Mutlu.
Thank you, Minister. Advocate Similani, the challenge I have as well is that what you were avoiding in terms of you having to disestablish that arrangement, the arrangement that you found to be uncomfortable. The basis of that, according to you, was to avoid being functus officio. Now you get a call from Advocate Bezos, and on the basis of that call, an arrangement is made and a conversation takes place, and you actually expressed a view in that meeting, where your view is that there is a case to prosecute, and you are not going to accept the representations, irrespective of whether they are formal or informal. But you took a decision then. So in that way, if Advocate Bezos was to proceed with a formal representation to the DPP, you would, and the DPP takes a decision that, or a view that they are proceeding to an extent that you would have to escalate that decision or challenge it to your office. You would have technically excluded yourself from the process and created a situation, an environment that would be unfair to the person who was making representations. Thus, you would become functus officio, a situation that initially would have
Not wanted to have.
avoided. You agree with me?
No, I don't agree with you, because I don't share the way you're characterizing that meeting. As I indicated, all that was indicated at the time is that I just want to discuss this particular issue with you to raise certain propositions about how we intend to approach the particular matter, right? We want to see if we can see you for that purpose. So I said, yes, you can come. I could have said, no, put everything in writing. So I said, no, it's fine, come here, if you want to come here. So that's how that meeting was. It wasn't a meeting in which that kind of discussion would take place. So it wouldn't follow the logic that you are submitting.
But then you make a request through the office of the DPP that the prosecutor handling the matter must come along to discuss the merits of the case.
No, not the prosecutor handling the matter in courts. It was a gentleman, I don't want to mention his name here.
But to discuss the merit of the case.
Not the merits of the case, to be there with me so that I have somebody else with me, at least who's familiar with the case.
Yes, to discuss familiarity with the case, to delve into the merit
No,
of
it was
the
not
case.
to discuss the case. It was to hear. Remember, they had not indicated what proposition they would want to take forward or what they would want to argue. So I said, okay, I'll hear you. It was only when he had arrived that he said, we want to make representations, and we would want to make representations in terms of which we're going to argue that this is de minimis.
Yes.
Yeah.
And you took a stand there, a position then, that that issue was not de minimis, that in actual fact you would, the prosecution will proceed.
No, I said I would not deal with that matter on the basis that it would be de minimis. The matter will go to court and be dealt with there, because
Yes.
that's where it already is.
So had this matter now been formally, or those representations, if they were formally presented again to you, would you have considered them, or would you have been, or become, or rendered yourself functus officio?
No, because there will be no decision. To make a decision as the NDPP, I would have to formalize it. So what would have happened if, to follow your logic, I would have had to say, let's say he's there, say, let me hear you. Goes into the full details or the merits and all of that stuff. I would also then need to know what is in the detail of that particular docket. At that time, I didn't know. I would need to be on all fours on that particular docket and then formalize a decision in the way of writing. So all of that was not even in question, because at the time, I didn't know the details of the...
So just to avoid dialogue, so you considered that decision to be an informal decision that you communicate or conveyed to Advocate Bezos?
No, it's not even a decision. I mean, it's simply saying...
It's an expression of a view.
Yeah, that I guess I would need to be involved in the matter at that stage, yeah. You can call it that, yeah.
While other colleagues are coming in, Advocate Shamila and I have a difficulty here.
With time. Oh.
You call a person who's involved in a case. If it was just listening, why didn't you take somebody from your office, in head office, to sit with you to listen? Why particularly you had to call somebody who was familiar with the case, coming through from being there to sit in the meeting, if the intention was not to deal with the case itself?
No, the gentleman is in the NDPP's office, but I'd asked him to go and speak to the prosecutor at the court about the particular matter to find out.
No, but
what
you are
is happening
changing
in
your
this matter.
versions.
No.
And there are two things that you have changed. One, you've said that you've asked the person responsible, you spoke to the DPP, because I asked. You said you spoke to the DPP, you asked for the person who was familiar with the case to come through. Now, if you are saying it's somebody from your office, so does the people in your office familiarize themselves with all the cases? At what point was this person in your office familiar with the case? Did they go to the... So I'm confused there. The second area of confusion I have on the statements that, as we ask the question, it seems to be changing, is the issue around what was... Because you initially said, I told Judge Bezos, we're not going to take representation. And you're saying it's not a decision. But for me, sitting here listening, it's a decision. You are the highest authority in the NPA that makes decision. No one else is going below you would be able to take a decision that contradicts the NDPP. We know the authority of NDPP in the NPA. Now, if you say, I don't think DPP, who's acting, would have gone and listened to a representation. For me, that's where the issue is. Understanding your level of authority in calling the people, calling this person. So if this person was not involved in the case and it's person in your office, how did that person become familiar with the case?
No, familiar in the sense, Minister, that, you could say to an official, please go to that court. I'm trying to understand where this matter is at, what is going on, what are the issues about. Official goes to that particular court, speaks to the official handling that particular matter, and comes back and gives one feedback. It is different from the engagement where you need the information for purposes of making a formal decision, because that comes through the formal route via the DPP. So this was really to get a hang of what that matter that is reported in the media about.
But if the intention was never to discuss the case, why would you go to an extent for a person in your office to go and familiarize themselves with the case?
Just so that I
Because
know,
the issue is, you are saying to us as a panel, you had no intention to discuss the merit of the case because you had no docket, and you had not been briefed by the person that was supposed to be briefing you, who's supposed to deal with the case. Now, why would you not then get the information and get the DPP to brief you rather than send a person from your office to go and get the case?
no, not to go and get the case, Minister. There's nobody who was going to go get the case, because that suggests something different. All that this individual was going to do was to go and find out the elementary facts about the case, so that when the meeting takes place, one is familiar. And then I hear what the advocate was going to be saying, and then have a discussion from that perspective. So it is different from a formal engagement. It's not mechanical in that way. So I'd let the DPP know that there was going to be that meeting about that case.
I've got Mfundisi, maybe just to ask, was this the modus operandi, where you'd have informal engagements? If somebody calls you and say, I want to see you, there's a case, you'd agree, have this. Was this an isolated incident or just the normality?
No,
Can I just follow up on that? That's exactly what I wanted to ask, Mr. Minister. Advocate, good afternoon.
Good afternoon.
My view is that, is this a normal practice? Was the once off? And did it happen again? Or was just because of Advocate Bezos that you've done that? Or is this normal practice, and has it done before? And did that practice continue doing that? And isn't that a prejudice? And isn't that a bias? Isn't that creating an opportunity for somebody to come and kind of use it as a bargaining or something like that? But is it a once-off, or is it, and was it normal practice? Thank you, Minister.
This one happened, it was a once-off, but about this case, it wasn't the only one. Because after Advocate Bezos left, he never came back. He never came back at all.
I'm just trying to think if we're not getting into a slippery slope where formal and informal seem to overlap. What if those reporting to you had started this practice of allowing for expression of view as a precursor, and those below them, and this became prevalent because the rules, the lines are beginning to be blurred? Wouldn't you worry if that was happening, that now you do have this expression of view prior to? Or would you just trust that you are the only one doing that if this became widespread?
So if I get it correctly, Prof, you are saying if those reporting to me, which is the DPPs?
Yes. And even prosecutors below, they start saying, no, nothing yet formalized, let's meet.
My understanding and my observation is that people do meet and exchange views and engage about the approach to the case, about what they would want to see the prosecutor do. There are informal discussions, even in the lower court. But if it is about trying to get the institution to take a final decision on a point, then that must be formalized, because there must then be consultations. So the generalized back and forth discussions, as far as I understood at least and I observed, do take place in the lower courts. It's not an issue. But if somebody now wants a decision to say, this is our view, normally prosecutors would say, please put it in writing and send it so that, and you motivate it so that we see why, and it follows the chain. Because by the time it gets to the NDPP, for example, you have a trail from where it started, how it was responded to by the people at a local level. It goes to the higher up to the DPP, who comments and also puts in writing. So by the time you sit as an NDPP, you have 2-3 stacks of interveners' opinions on the matter, and then you deal with it on that particular basis, because you are reviewing a decision that's already been taken by others. That's how it works.
Thank you, Advocate Shamila. I think you are right. By the time it gets to you, it would have been a decision that is taken by others. But what protections would you give to the system that the person, when they go back to come up with the value chain, are not actually saying the NDPP has seen this, or I've expressed my opinion to the NDPP, in that way, bearing weight on them to look at it in a particular way, almost like you do not have a choice because this matter is being handled by the, or even outright, I've spoken to him on such and such a day, you know, that kind of thing. But I just want to refer us to the Code of Conduct of the NPA under professional conduct, which says prosecutors must strive to be and to be seen to be consistent, independent, and impartial. So there's the issue of perception there. Yeah. And it worries because once you call somebody in your office, when there is somebody defending another person who's accused, it gives a perception. And then it will come back, like you say, now formalized. And it comes back to you as the final arbiter or somebody who is supervising a final arbiter.
Right. The good thing is that it would never, ever happen that way. I can assure you that in the NPA, whatever you may have heard, prosecutors follow strictly the channels. It's SPPs, it's control prosecutors, it's the deputies, it's the DPPs, it's the head office, when formal decisions are being taken. But when there's back and forth engagement in a court, they have those engagements as often as they need to have them. But when it's time to make a decision, you put it down in writing so that you understand it, and also so that you consult about what the attitude is, up to until the absolute level. So the concerns you have can never ever arise in the normal course of operation of the NPA. It doesn't work that way at all.
Okay. I want us to move on to the next segment, Advocate Shamila, into the legal background. You indicate in terms of
into the legal?
Pardon?
I beg your pardon.
Yeah, section 2 of the form. Around, maybe check us through your exposure in terms of legal work. I see you've got criminal law.
Section 2, yeah.
And we're saying not a lot. Administrative law, constitutional law, labor law. Maybe just take us through that exposure.
The section 2 paragraph.
It's on paragraph 2.2.
Oh, 2.2. Oh, no, these are the areas of law I practice in. Yes. I do varying amounts of work. Mostly it's admin law and constitutional law. Done a little bit of labor law. It's not a big area of work. Criminal law is not incidental enough. Compared to what one would expect, I haven't done a lot of those types of matters. I've done a few of those matters. I've done a few family matters, family law matters and Hague matters, but it's mostly admin law and constitutional law.
Then we move to section 4, managerial experience, having led NPA.
Can I ask one question?
Okay, you want to ask on that section of legal?
Yes.
Okay.
Thanks. Advocate Smilani, just so that I don't miss this part that you just said. You said criminal law matters, you have not done so many.
Yes.
Does this answer include the period prior your appointment then, moving into the period now? And I understand that as counsel grows in practice, people don't go to do bail for every matter everywhere. But does this also encompass the part, perhaps, of prior your first appointment?
Private at the NPA?
Yes.
No, I did quite a bit before.
You did
Yeah, I
quite
did
a bit before.
quite a lot of matters before. Yeah, I did quite a lot of protests.
So you can easily answer to the question, you had adequate experience in the criminal court.
Oh no, before I went
space.
into government, yes.
Yes.
Before I went into government, yes.
Okay.
Yes.
No, that's
Okay. No, thanks. Moving into the managerial, I'm not worried about how many staff you've overseen,
Yes.
having been the head of NPA, but I'm interested in your management style and your leadership style. I see here you wrote in terms of leadership, you advocate and practice the African-Asian approach, which fosters community and village. As a person, I think I'm reading it correct, it's part of a whole. Maybe explain that and also what you see as your management style.
Yeah, it's collective engagement. I don't do top-down. I don't manage people top-down. I believe in communal kind of engagement where you meet the people with whom you work, even if you are superior to them, and you share ideas. That's how I've been managed. It's the only style of management I know. I've always been, from the first time I worked formally at the Competition Commission, it was always group thoughts. We meet as a group, we meet as a collective, we set the plans, the strategies together. Naturally, the leader will help identify the priorities, but we sit together, we agree, we assign the role, you come back, you share that role, and you report to the team on a regular basis on your work. Decisions get taken collectively. You decide on what others do, others decide on what you do. So that communal approach, I found that for me, it quickest enables buy-in. You don't have somebody feeling left out because they're just getting informed after the fact that something was done. So when you're together like that, then that's how it works. So the EXCO style is that. What I do when I say I don't manage people, I manage process instead. I set timeframes and dates. So for example, in the Department of Justice, I would say to the DDGs, we're only going to have 12 meetings a year. One meeting a month, which takes place in the first week of the next month, so that to discuss the month prior, so that we collect all the stats for that month and then discuss them the following month. In between, I don't need to see you because we've already agreed on the strategy, the objectives, the plans. Just go and execute and just give reports. So I hold people to account on the timeframes set, the target set, and then off we go and make decisions that way.
And I want to come to that leadership style. One of the candidates in the my apologies. I think it's a long day. I want to come to the leadership style and acknowledge what you are raising about inclusion, participatory of staff. But one of the candidates earlier on spoke about you being able to undermine those that you lead with, as far as sitting even in panels of junior officials in the appointment process.
Oh, Hermione? Okay. No. No. She's correct about that. That I did do. Mm-hmm. The context was this. I raised an issue in the organization. I said, guys, or incidentally, we know each other very well with Hermione. After the meeting, we're busy chatting there. I was telling her, how dare you say this about me? She says, well, you know who I am. I said what I had to say. So I told her to say there's no, I absolutely accept what she said, and it's correct. I did do that. Again, you arrive in an institution and you get on with work. as would know, for many of those that work in institutions, officials then come and give reports to the new people to say, look, there's a problem. It's of this nature. Dissatisfied with their work environment. And this was a few. Some people in head office complain about it. Just basic petty stuff. So I was like, nah, I'll talk to you. So I tipped Vili. I said, hey, you know, there's grumblings I hear about in your area. Just keep a close eye on it. Then a while later, I went to address the team just to meet them and see them. And we discussed work in the normal course. Again, nothing hectic, nothing unusual, because I was just loitering to see if I can pick up some stuff on a consistent basis that I could raise formally now with Vili, because he was a good colleague and a comrade. I just thought he needed to be aware ahead of time that there was something coming up. Then when I looked at the work of the unit, I asked just informally, why are there no black people in the AFU? You know, why is the representativity or representation so poor, comparatively speaking? The initial discussion, we're sitting like this in a room. The initial discussion was, yeah, we're looking, you know, we're advertising, we're recruiting. You know, so I said, okay, no, that's fine. The meeting ended, normal course, no biggie. Then we had another engagement with the units, and I raised the question again. I said, no, but why is this issue coming up? And this time I started raising it formally, that I'm getting negative vibes about the place, that this is a preserve. There's no inclusion in this particular unit. And the formal answer that I then got was, we can't find good black candidates to join the AFU. So I said, no, I don't understand how that could be. What do you mean? He says, no, we get CVs, we interview, we don't find appointable people. It got on for a while, then I involved another official, Advocate Shamila, senior official. I said, this...
Oh, they're asking that you bring closer your mic.
I asked Advocate Jiba to join me in some of the meetings. I can't remember what she was responsible for at the time, but I asked her to join. I said, no, I hear this thing, what is going on? Then I received a formal complaint from an AFU official to say Vili of Meyer is racist. So I dismissed it. I said, no, you're joking. No, not Vili. You know, it can never be, I know. I said, no, he's racist because we are being made as blacks. There had been then some recruitment of blacks. We are being made to write an English test. So I said, what are you talking about? You're being made to write an English test. I said, no, I'm being made to write an English test. So I didn't believe it. I said, it's not true. Let me see it. So a small sheet was brought to me, and I spoke to Vili about it. I said, Vili, what's going on here? This is what I'm getting. You know, at University of Natal, where I went, it had a program of assisting students for whom English was not first language. And as part, it was a bridging program. It was called English Language Studies, to help them bridge before you do English 1, 2, or 3, if you wanted to do that as a major. This was worse than that. I called Will, I said, Vili, this can never happen. I can't get this from you. It can never, ever, ever happen. He said, no, we're just trying to do basic tests. I said, it can never happen, because it creates the perception that I've had. I know it's not true what they're saying, but that's how they feel, because they see this kind of treatment. He says, okay, no, then I'll stop it. I said, no, don't worry about it. Let's not go ahead with it. I'll go and engage with the officials. So I went and engaged with the officials, and I basically indicated to them that whatever their perceptions were of him, it really, I understand why they would feel that way, but it definitely was not what they were describing. He's absolutely not like that at all. They understood, they said, we understand, but we didn't appreciate the manner in which we're being approached, because there's this general problem in the AFU. So what I then said was, well, you know, and I spoke to him, I said, well, in the next set of interviews, I'll come and make sure that we're able to see if we can find candidates that can fit the bill. So I spoke to Vili. There were appointments being made in the Western Cape. And I said, I'm going to be in the Western Cape for something, so we're going to be participating in this. He didn't have a problem, right? But then I asked him that, well, if you can speak to your officials about it, so that they're not surprised when they're there. So we arranged with HR, and we went to the Western Cape, and we handled it. In other words, the process was run, people were interviewed. HR had handled everything already, so we just came, we had a look at the pack, we sat and went through interviews, and candidates were appointed. And my submission that we found the candidates that could do AFU work. My argument, Ella, with Willie, when he said we can't find people, I said, tell me what's so difficult about AFU work. I just want to understand it. Because by that time, I'd also checked that when it comes
and I'm going back to the theme, because you introduced the theme of ensuring that your heads have power. Your heads don't feel undermined. Now, if it's the process of rectifying, you're wanting to support Vili in finding, Advocate Hofmeyer, in finding the right candidates and also ensuring transformation. Wouldn't it have been better, or why didn't you go with Advocate Hofmeyer, who was the head of FIU? You went with Advocate Chiba, who was not responsible for that unit.
No, he didn't want to go. He said he didn't have to go. At the time, remember, at the time, he was also running the SIU. So I spoke to him about the positions they were filling. And we actually discussed them, that, okay, I'll be going to the Western Cape to go and participate. He said, no, it's fine, you can go. I'll speak to Hermione about it, and you guys can attend to it. It's not a problem. So we had discussed it.
Advocate Cronje was responsible at the provincial level, because our understanding, she says that there were two people that she reported to, which you jumped from your level to come to her.
No, I don't know those two people. It could be true, I don't know. But the arrangement for those interviews was arranged with the head of the AFU, sorry, it's Asset for Future Unit. And I went there on that basis to join those that were there. I don't know who else would have needed to be there, how they had set up the process. All that they just needed to know is that the NDPP would be participating, I think NDPP, I think at the time, would be participating in these particular proceedings with HQ.
And when she wrote a complaint?
I've never seen it. I've never seen it.
The report that she wrote to raise her dissatisfaction.
Never brought with me.
You never knew about her not happiness?
First time I hear about it today.
It's your first time today?
First time I hear about it today. What would have happened in an event, Minister? HR was there, ran the process. HR ran the process together with some of the admin people who were based in the Western Cape office. And what would have happened in normal course is that if anybody would have raised a problem with the process, it would have gone to HR, maybe not there. Let's say, I don't know, I'm trying to imagine that she probably, let's say she thought, let me do it when the acting NDP has returned to Pretoria. That would have gone somewhere. To HR, it gets to HR in HQ, and it gets looked at. And if, for example, somebody is complaining about the NDPP, acting NDP at that stage, I'm imagining that they then would have found a way to take it to an appropriate environment for it to be addressed.
Yeah.
So what would have happened is that it would have come, they would have looked at it without my knowledge, for argument's sake, and they'd have taken it to the department in HQ, where HR reports anyway, and it would have been submitted there. And I'm imagining that should have been asked, is it a formal grievance, for example, or is it just an information issue? Let's assume, worst case scenario, it's a grievance. It would have been a grievance that would have really raised the, let's say, the DG's attention, the DDG, they would have taken to the DG to say, DG, you know, this is what is happening, can this be followed up and taken up? So I'm imagining if there's a complaint of that nature, that's exactly how it would have worked. And if it was not satisfactorily done, I'm imagining that whoever feels strongly about it would have escalated it to the executive authority, because that's a grievance framework in terms of the public service, and it would have ended up in the Public Service Commission to the extent that somebody would have felt aggrieved. But Mr. Hofmeyer never raised it with me at all, at any point in time.
So you said in the interviews, were you part of the shortlisting process?
I don't recall if I was part of it.
So you
No,
only
we
said in
got-
the
I
interviews.
think when I got the pack was already prepared there.
Who
for everyone.
shortlisted, in your knowledge?
Oh, I don't remember who they've shortlisted.
The reason I'm asking it because it makes that process irregular if you didn't shortlist.
I just don't
The
remember.
requirement of a recruitment process is that you would advertise, a panel will be appointed, that panel must shortlist, and the same panel that have shortlisted must be the one that interviews.
Yeah, I don't remember how it exactly worked. I may have been part of actually the shortlist because it was an intervention specifically that I was making, but I just don't remember the details. I don't want to commit, but it's verifiable.
Advocate Shamila and I have a difficulty with that. You are a former accounting officer who have run the Department of Justice and Constitutional Development as an accounting officer, who would be familiar with HR processes. Because as a Director General, you'll sit in interview processes. You'd oversee the process of recruitment in terms of public service and administration. You'd understand the law and the regulations that requires. I find it difficult that at this point, you would not know that I can sit in an interview if I've not shortlisted, or you do not remember whether you shortlisted. I've been a minister since 2017. I've been a public servant. I can tell you where I've sat in an interview.
Mister, I've sat in many interviews.
I've sat in many.
No, I understand. And that process you are describing is exactly the process. I just don't want to. I'd appreciate if you verify it. I just want to.
Okay.
I just don't remember.
Let's take a step back and park that one.
Yeah. Okay.
In terms of public service and administration, as a former accounting officer, you would know the levels of delegations. That at this level, as an accounting officer at a department, you'd have been given, okay, at this level, administrator to this level, non-SMS. These are the delegation that would operate the appointing and all that process. SMS, this is where the delegations and all that. For example, DG, DDG, we go through cabinet. It's delegated powers by cabinet to ministers, and therefore the panel will be ministers. Non-SMS based on public service administration and delegation by the executive authority, which again, in the NPA, the delegation as well are linked to the minister. Now, at the time you sit with this, did you verify the delegation authorities that you could sit in that, or you are violating those delegation of authority?
That I could sit as NDPP?
Yes.
No, I didn't get that far. No, I don't. No, definitely. No, definitely, because the NDPP would not have the delegations for HR.
Exactly.
Yeah, no.
So you shouldn't have said in the interviews, because there is nothing that gives you that authority to sit in terms of the delegation and functioning, how NPA functions and the department, especially on human resource processes.
Yeah, no, I take that point, yes.
Thank you. Okay, let's move to the next one. In terms of the questionnaire, we move to, you've dealt significantly in terms of your significant contribution, where you've gone into detail in how you have explained your role in establishing the Competition Commission, the tribunal, the work in conceptualizing the DPCI. Anything else you'd want to say in that regard? This is section, I must go in paragraph 3, same under section 4. If you've gone extensively, but I don't want to pass in case you've wanted, because you covered it when you started the process. But I don't want to be unfair and jump that part. If not, we can move to the next segment.
Yes, Minister, there's a lot that I've done.
The next section deals with financial and business interest. You indicate that you've got 2 companies. We did receive your letter. Thank you very much. Where you have additional in terms of the company that is also dormant that you'd forgotten to indicate. So that is received. They are currently confirmation that you are currently deregistering them. Thank you. And then we move, okay, the issue of health, no health issues that will impede you from holding the position. And then we go to the issues around, have you ever been convicted? No. But the issue of legal bodies, any complaint, have you ever found guilty of any professional or disgrace conduct and any complaints against you? Do you want to take us through that process, those issues in that segment,
that's
where
three,
there's
right?
complaints, issues that you'd want to bring to the panel and your explanation of them?
Oh, yeah, that's the Johannesburg Society of Advocates matter. Yes, I indicated that matter. That took place in the process started in 2015, it finished in 2017. That arises out of the Khanyile processes. I don't know if you want me to start there. Do you want me to start there, Minister?
You have an opportunity to explain to the panel,
Right.
and I'm giving you that opportunity.
Right. Okay. Now, this matter followed the Khanyile inquiry, which got completed in 2008. There, it was an inquiry relating to the fitness for the NDPP at the time. As DG of Justice, I then assisted the minister with that process at the time. The way the terms of reference were set and the way government decided it would approach Khanyile was to make a submission. Dr. Khanyile asked those submissions. The reason is because it is initiated by the president at the time. They therefore needed a submission to be made that would be considered. That submission was prepared. It was submitted. In its preparation, because there were no directives as there usually are with the judicial inquiries, this wasn't a judicial inquiry, but there were no directives. There was a due date for government to file a submission. So all information had to be put together. The department was instructed to find legal representatives for the minister and the president. So in the normal course, I facilitated that through the state attorney. The state attorney made available state attorney to represent them, and through the state attorney, counsel was found for the minister and for the president. And they engaged and took instructions accordingly. They met often. In some meetings I was invited, in some meetings I was not. But the long and short of it is that government therefore needed to put together a submission. So the nature of the issues is that the president would make the inputs in relation to his views to the issues, and the minister would provide inputs in relation to her experience with the NDPP. And this was on the basis that the minister had advised the president that her relationship with the NDPP had broken down. So she needed therefore to have collated and put together all the information that she was going to rely on to demonstrate that. So the department was asked to put together information. We did that. The other departments that were involved were asked to do the same thing. NIA was asked to do the same thing. Crime Intelligence was asked to do the same thing at SAPS. So there was a collation. So what I was responsible for as the DG in the department was to coordinate the meetings of all the departments that were involved in that submission. So I arranged meetings with SAPS to tell them when the meetings were taking place, what was required of them, so they would come. Inside the department, those officials who had dealt with the NPA and the DSO, amongst other things, I'd asked them to bring that information. So they all came and would meet and then would brief the lawyers and show them what information we have. And the drafting of the submission, therefore, was done by them and would make inputs periodically. And we discussed it, and up to the point where they then needed to go back to clients, discuss it further, and finalize it because the submission date was imminent. So that got done. So that was the end of my contribution to that process. And the next time the information came back was that the executive authority and the president had finalized the submission. It was now going to be filed. And the legal representatives were responsible for that, then did file the submission with Khanyile. It wasn't the department's responsibility. So it was submitted just as a submission. And then when it was received by Khanyile, naturally it was considered. We then got information back that, or before it was submitted, there was then a letter from the attorneys of the NDPP asking for information. They asked specifically for a letter. Well, they didn't specifically ask for a letter, but they asked for all information, if I remember correctly, I'll paraphrase, that the department had received, the ministry had received, the department had sent, the ministry had sent to the president. So either of you would have sent to the president or whatever either of you would have received from the president before 15 September, if I remember correctly. So we attended to that. I was instructed to then obviously assist prepare a response to that particular letter. And I did prepare the response to that letter. But at that time, the minister indicated that indeed she has a letter from the president. She had received a letter from the president relating to Pikoli. And she suspected that the president was going to be making a decision soon. She didn't show me the letter. She didn't give it to me, so I didn't know. But the discussion was the reading and the letter from the attorneys is asking for information in relation to the prosecution and arrest of Mr. Celebi. That's how Mr. Celebi. That's how it was phrased, if I remember the wording correctly. So the point made was that we know nothing about. Well, I hadn't received anything as a department. In other words, the department hadn't received anything from the president and hadn't sent anything from the president. So this didn't naturally concern the department. It clearly concerned the ministry. And the minister's view was that I don't have a letter that talks to the arrest of anybody, let alone Mr. Celebi. So that's the response that needs to be sent to these parties to indicate that there is no such. But what was there were all the other reports that had been submitted by the NDPP. So I drafted the letter along those lines, and it was sent. The submission then got submitted to Khanyile, and I was informed that the legal representatives, when they got there were engagements with the legal representatives of the NDPP, and it was in relation to what they still needed from the department and the ministry, respectively. In fact, they'd also asked, I can't remember when, but at a different time, not in the same letter, they'd asked for opinions that the department had obtained. And the department claimed privilege over them and said, no, we're not going to make them available because they're privileged. So in the meeting with Dr. Khanyile and the Secretariat, there was then a discussion about what the other side needs to start. I wasn't there, so I don't know what happened, but this is the feedback we received. When it came back, the feedback was that, well, between the parties, because the process would need to start soon, some direction was given by Dr. Khanyile, and it is that, and this was agreed by all the parties, that they would exchange what they need from each other. So let there be a discovery process, in terms of which what the other side needs, the department and the ministry must make available, and the other departments as well. They must make available, and if anything is needed from the other side, the same must be done. So with the officials, we put together the information, specifically the 2 opinions that we had claimed privilege over, and we waived the privilege, and we gave them to the state attorney. The other departments did the same, as far as I recall. And then those were given to the legal representatives, and they attended to their filing with Ginwala. A couple of days or a week or 2 later, then the process started. So that's how it started. Or in fact, before it even started, part of the feedback was that the legal representatives of the NDPP said the government submission covers too many things in one. And because there's too many things in one, can there be a breakdown of which department is raising what issue and which person in that department is raising what issue? So it was segmented, and myself as head of department, I was then, and that parties must then also put affidavits. That must be done in affidavit form. So I then did an affidavit to cover the areas that related to myself as head of department and accounting officer. I explained the issues that I'd reported to the minister about in relation to the NPA, that I was having difficulty about with the NPA. Basically finance reporting issues as accounting officer. And as in terms of Public Service Act, it was in relation to 1 or 2 disciplinary matters, and the building in its chambers that had been acquired by the NPA, for which they needed money to refurbish. I put those things and the general issues between NPA administration and departmental administration, where staff were heckling each other back and forth about reports needed to be submitted that were not submitted. So my affidavit was basically circumscribed to those issues. And it was filed. I think the minister, if I recall, did her affidavits, and the other officials from the other departments did theirs. So those were filed, basically discovery. So discovery was done, and the documents went through, and then the process started. Then we went through it. I was cross-examined on my affidavit, at the end of which, naturally, I was excused and I left, and those who were remaining proceeded with the process. The next thing I see this, I hear that the Ginwala report is ready to be released. We all waited for it naturally, and it was eventually released and it was attended to. So when I got a copy, I then saw these comments that were made by Dr. Ginwala in relation to myself. I was obviously shocked by them. I was like, wow, why would these comments be made? Because not only do I not agree with them, but I didn't get an opportunity to be tested on them or comment on them. So how can this be? Processes just ran forward with the removal of the NDPP in Parliament, and this issue got left unattended. And things basically continued in the normal course. Then I got alerted that somewhere in 2009, I heard that somebody had filed a complaint, but initially I didn't get that information, and it sort of died out. But in about 2011, 2012, somewhere around there, then I got information that, no, indeed, you were right, there was a complaint that was filed by an advocate, Ellis, who had filed a complaint with the Pretoria advocates saying that the comments made by Ginwala needed to be investigated. And that matter was then referred to the Johannesburg Society of Advocates around that time. At that time, the judgment had come out and I was at home for a while. Then around 2013, I then went to join the Public Service and Administration. And that's when the Johannesburg Society of Advocates then contacted me and alerted me that, look, we've got this complaint about you, can you just comment? So I commented and explained myself. Then they said, no, we believe that we should take this matter forward and there'll be a disciplinary process. I said, no, that's fine, I'll come and explain. It started in 2015. We had exchanged representations, which they're not satisfied with. Then in 2015 it started, and we completed it in 2017. Found guilty on the way the charges were framed. They were in line with the comments made by Ginwala, that you didn't disclose to Ginwala the letter of the president. You didn't follow the advice of the opinions. You got yourself involved in the NPA and therefore exceeded the role of the Director General in respect of his responsibilities for the NPA. You were condescending and arrogant to the NDPP. You accused the NDPP of dishonesty, and then you conceded.
Away from the mic now.
Then you conceded on an accusation you made, and I find that it was without merit. So those comments were mirrored in the charges, and they found me guilty of that. And they recommended that a strike-off application be brought. That was in 2017. Then within the 14-day time frame set, we filed an appeal to say, no, we're filing an appeal with the GCB in terms of the Constitution, and let's attend to this. Never heard from them ever since. Never heard from the JSA ever since. So 2018, 2019, my attorneys engaged them to say, look, we need to have this appeal set up. We filed and everything is ready. When it's going to happen? No acknowledgement of receipt, nothing. They do absolutely nothing. So my attorneys say, no, let's wait. Maybe they will come back. So we wait. I continue with my work. Then reach a point at work in 2022 where I thought, oh, well, I think it's time for me to return to practice. So naturally, I went back. I applied for membership to a group. I got it. And then I went to take up chambers around about March 2023. And I started phasing out my special advisor role. But my chambers were set. Then around March 2023, I saw in a totally different function the chairperson of the GCP at the time, and I just reminded him, I said, there's this thing outstanding. Since we filed that time, we've never heard from you people. He said, oh, you know what, I remember the thing. You know what, we'll respond to you. A few weeks later, we got a response that GCP doesn't have jurisdiction on the matter. I'm like, oh, okay, they don't have jurisdiction. Okay, that's interesting. That was about March 2023, April 2023. Then around June, July 2023, I'm not so sure, the JSA then sent me a letter to say that, look, remember this matter? I said, yes. He said, when I have a look at it, can you give us representations on new issues that you would want us to consider as we consider that matter? So that looked strange to me. I was like, okay, I'm not sure what procedure this is, but okay, let me do so. So I got my counsel and my attorneys to put submission. We put a 40-page submission, practically expressing concerns that, look, here's correspondence. We've been engaging with you guys from day one. You've not been responding. You've not been acknowledging. These are the views we have. Put a full submission about, the prejudice that's there. Why is this thing taking so long? Why didn't you move on it? Then, after submitting them, I was then informed that the Bar Council would be meeting around October 2023, and that I was invited, if I was interested, to come and meet the Bar Council and come and make my presentation there based on what I'd written. Naturally, I took it up. I said, oh, of course, no problem. I need to come through. So I went. So went with my legal team, we sat there, everybody was there in the Park Council at the time. And then they said, well, we're here and this is the only agenda. We'll receive your submission. We just want to find out if you have anything else to say. So our approach was simple to say, first of all, tell us what process is this in terms of the constitution of the society, because we've looked at it. There's no provision for this procedure. So what procedure is it? I need to understand what is the purpose of this discussion, because all the decisions have already been taken. The only thing left is for the appeal to be set and be heard. So what is this meeting? And they all looked at each other and said, oh, we're just trying to find a way in which this can be amicably resolved. Words to that effect. So on our side, we said, no, but what procedure? You know, we can engage in a discussion if it's in terms of X procedure, but what procedure is this? Because we're not aware of it. And what amicable resolution can there be in a matter like this? Because an appeal has been filed and it is there. It just needs to be processed in accordance with the relevant clauses of the Constitution. So I went on as well and told them what the prejudice is. And I specifically told them, I said, you know, the problem with this type of thing is that this thing is hanging. And if I need to go and do something, this thing will always need to be explained. You know, I gave them examples in the public service of positions where fit and proper is a requirement. I said, for as long as these things are there, this thing will always be hanging. So you need to finish this. And you've been prejudicing me for the past 8 years, as the case may be, by not attending to this. I said, no, we realize that we will we'll consider this if there's nothing else to say. So there were further arguments. I don't need to repeat them here, but really premised on the fact that that process and that meeting was just a non-meeting in the sense that what did it have powers to do as far as we're concerned? We wanted to understand that. We didn't get an explanation. So I said, we'll come back to you. So we left. Never came back to me. They never said a thing. I said, oh, okay, these guys are quiet. Then, lo and behold, this process starts. The president puts out a panel. It's in the media. And, that advert or that gazette in the paper, if I remember, it was a gazette, but it was basically the panel. It was put in a WhatsApp group I'm in. And somebody in the WhatsApp group, it's a WhatsApp group of many people really from different parts of the country, different political parties. And somebody in that WhatsApp group said, Menzi, I expect to see your name in there. Words to that effect. I think it was on early in the week, Monday or Tuesday, somewhere thereabouts. I don't remember. It's fine. Then same week, I go to Chambers on a Sunday to go pick up a document I needed to read. And I open my chamber, I get in there, there's a huge box. And I thought it was the document I was expecting. So I go and have a look and I open the box. It's the strike-off launch papers. They're on my desk. I'm like, okay, what is this? I look at it and I see it. I'm like, oh, okay, this is what has happened. And then I attended to it. So I was trying to think what was actually going on. Then it dawned on me that, oh, okay, actually, this is, it appears to be a preemptive move on the part of somebody in anticipation of something. And I left, obviously, and engaged my lawyers accordingly to say, can we look at this thing? These guys have, since 2023, October, they've only come back now with this application. So we checked, obviously, when it was stamped and served so that we comply with the timeframes, and we attended to responding to it. So I spent some time thinking about, okay, what possibly is happening. But because they'd moved in this way, my thought was, okay, obviously I'll defend it and see them in court. We will proceed. And we prepared the papers, and we filed since accordingly, and they've since responded. And we've put a counter application to have the matter dismissed. And they haven't yet. Time hasn't come to file their answering affidavits because they asked for an indulgence to file in January, which I acceded to. But they haven't filed their reply to my answering affidavits, and they're out of time. So they indicated that they will ask the court for condonation when they file. They were due to file their reply on the 26th of November. So we're waiting. That matter is sub judice for these purposes, Minister. But that's basically what happened in this particular matter. Now the issue is, to get back to Ginola, what actually did Ginola say? And is she actually correct? Because after the reports were released, her report was released, and it went on, the matter went to court, and it was set aside. Based on the judgment, I then engaged government to say, okay, we need to attend to what the judgment says. And the responses I got was that, no, it will be attended to. We'll attend to it. We'll have a look at it. So in the meantime, the first
Court
thing,
set, you mean the Concord setting
Concord.
aside your
The appointment, yes.
not the report?
no, the appointment, the report, I didn't challenge because I had no local standard to challenge it. It was a comment, those were comments made against a witness. So I had no interest in that inquiry. So in law, I wouldn't have local standard to set aside a report. I was in a process I wasn't a party to. So that's what basically...
But the report makes a finding. I find it difficult, Advocate Shamila, that you would say you had no local standing. If a commission finds something against you, I find it difficult to say you couldn't challenge it. You could challenge and review where it makes provision about you.
No,
Not the entirety of the report, but because
that's what
it
I thought.
made observation about you, and you didn't challenge that part about you.
Well, that's the
And
advice
that's
I
why
received.
I'm responding to the part where you say you had no local standing in terms of challenging. You do, because the part where it makes reference to you, you could have challenged that part. Not that you didn't entirely have local standing.
Well, first, the position was there's no findings being made about you, firstly. It's not a finding. These are arbiter comments, right? That's the first thing. And if there's no findings against you, it doesn't affect you. The report doesn't affect you. And to the extent that arbiter comments were made about a witness, and because you're only a witness, you wouldn't have local standard, and you don't have local standard to try and set aside the report on that basis. That's the
But the
legal advice I
Ginola
received.
report did make a finding about you.
It did not.
The issue of dishonesty,
It's not in the findings. It's arbiter in the body of the report. It's not a finding. It could not have been a finding, Minister, because the inquiry was not about me. The inquiry was about somebody else. I just came as a witness to talk to specific issues. So the chair of the inquiry, for whatever reason, found that I'm not happy with this witness. She makes a general comment in the body of her report.
but there
Against
was an issue that you President needed to act
no,
on those.
not in the Ginola report.
The Concord says that.
No, I'm going to get to the Concord. No, so the Ginola report is simply about a witness and the dissatisfaction of the chair with the witness. It also happens in courts where a judge can say, I was unhappy with this witness or that witness or the other, right? And then continues to give judgment in relation to those before the court, right? So the issue is as a witness commented on, can you go and appeal that judgment or review it? You can't, because you're already a witness. So same applies here, that you're just a witness. It was arbiter. It wasn't a finding against you. So there's nothing for you to challenge. It's just unfortunate negative comments about you, but they are not findings, right? So that's how that matter was left by myself. Then in the CC, the mistake, and I've got the judgment. I don't know if you have it, because I want to show you where I think the error and the confusion arose. In the CC, Justice Yakub says, of the judgment. Yeah. On page 34 of the judgment, the first error that is made is that at the bottom there you see the heading, Ginola Commission findings. It's the first error because the justice there says those are findings when they are not findings. They were not findings. You won't find them as findings in the report. Comments about me are made in the executive summary. They are not findings. So that's the first thing. And on that paragraph 50, Justice Yakub correctly says, in the executive summary of the Khanyile report, Dr. Khanyile said of Mr. Similane. Then on the next page he goes on. But that's in the executive summary, it's not in the findings. But for whatever it is, whether technically there are findings or not, the point of the matter is that what needs to be addressed is the negativity thereof, so that it's responded to.
That's why I could have picked up, because the Concord does make reference to it as a finding.
No, I understand, yeah. And as a result of that, I think the media then also reports accordingly. So Justice Yakub deals with it in that fashion. Then on the next page, paragraph 51, correctly says in the report of the Khanyile, he calls it a commission, it wasn't a commission, it was an inquiry. And there is a legal difference between an inquiry and a commission for reasons that we all know. Then he copies those comments. But on paragraph 51, if you go to what is quoted there, the last paragraph, which reads, with regards to the original government submission, the issue there is that when Dr. Khanyile makes the comments, she makes reference to the government submission. She's talking about the government submission. She's not talking about my affidavit. So what is the difference? When she talks about the government submission, as the DG, I'm not responsible for the government submission. The parties responsible for the government submission would be the executive authorities with their legal representatives. I'm not responsible for that. Right? That's the first thing. So that's how a wrong view starts to get created, because Dr. Khanyile herself makes reference to the original government submissions. As she says, many complaints were included that were far removed, and she goes on and on and on. Then she then says, this further reflects the DG's disregard and lack of appreciation and respect for the import of an inquiry established by the president. So Dr. Khanyile makes an error in that she makes the government submission my responsibility, which it wasn't. It wasn't. It was the responsibility of the executive authority. So that all gets covered. Then let's deal with the specific.
There?
Yes.
Let me just reflect for a moment. In the Khanyile report and in your response subsequent to that, you make a point that this is just the government submission, not yours. And you become a passive actor in the process. I put it to you that in everything that you have presented, you are an assertive, decisive person. And you said earlier you coordinated submissions from different government entities. So I would find it difficult when you say I'm a passive victim, not an active player, in a sense. So to me, I just want to come straight to your view on the issues, because right now we could be sliding towards the technical aspects of the report. Fair enough. The bedrock of the role, whether a DG or the National Director of Public Prosecution, they put the issue of ethics and integrity. And the operative term there in the NPA Act is the one to say to be fit and proper with regards to the experience, conscientiousness, and integrity. And there's a reason why, for these particular roles, they put the issue of integrity, of ethics, because right now we might be playing with the technical aspect of the report itself, right? So to me, there are observations made in the report about you having withheld some documents, not cooperated, not being a reliable witness. Those are very specific. Whatever technical term we can use, those were made there. And you would have said, let me challenge that particular aspect in a report because it impugns your own integrity. Would that not be the case?
You're wrong on a number of fronts, Professor Figin. There's no technicalities that was getting into. And I resist your temptation to want to avoid the issue because I want to make these issues that Dr. Khanyile raised an issue for you as this panel to think about. So I'm not going to accept your characterization of the issues I want to raise as technical issues. I'm not going to accept that because if I accept it, what's going to happen is that this issue remains unattended, and it's been unattended for 18 years. So I'm not going to allow you to go that route. That's the first thing. The second thing, that I'm not sure where you're getting this expression passive victim, because I never said that. So I believe that let's not do that. What I'm saying is the submission of the government submission, the filing of the government submission to Khanyile is a responsibility of the executive authority responsible to make that submission. That's a legal issue. Who has responsibility to respond? It's the person responsible for that. In the same way that the minister currently should be responsible for the substantive work of the Madlanga Commission and the Khambebe Commission, as far as representing government as the executive authority, not a DG who is a functionary administratively. In the submission, contribution to the submission, I was definitely an active player because, as I said so, I don't know if you heard me, as the DG, I was making contributions in relation to the issues that affected myself as DG and as head of department in relation to the NPA. So I made those contributions in that particular submission. Similarly, with the inputs from the international relations officials of my department in respect of mutual legal assistance, I provided that information to the legal representatives towards the submission. So the submission contained that information. So I can't be passive under those circumstances, but I'm contributing to it. Now, once that is done, the question is what then happened? And what happened thereafter is that the executive authority and their legal representatives then finalized the information and finalized the submission to their satisfaction. That process does not involve the officials, and it didn't involve me, despite having contributed to it.
Let me come there. Understanding the role of the accounting officer, Advocate Shamila, I do find it a bit odd, unless if that minister acted, because the Director General in a department is the advisor of the minister. They, like the same, where the minister becomes an advisor, or we'll call it a counselor, to the president.
Yes.
Now, you are saying this work excludes you. It's that of the minister. It was the minister working with her advisors. Is that what you are saying?
No, that's not what I'm saying.
Okay.
I'm not saying. There were two processes.
Okay.
The first process is first compiling everything that's there. Government must make a submission. Everybody that knows something, bring whatever you have. Got involved in that. I was part of that. I coordinated that. Everything was put together. We have these regular, it was more than one meeting of officials together with the lawyers. How do we frame this submission?
And justice is the lead, Because if there's a coordinating, for example, it takes the format of in ministers, it will be an IMC, where then the minister who chairs that, because there's always a lead department. So in this regard, you'd be the lead department as justice
Yes,
to
because
coordinate all this information.
yes,
to
to become
collate.
lead department because the inquiry is run by the department.
Yes.
As you know, Minister, all
Yeah.
inquiries are run at justice. They can't be
Yes.
at Home Affairs. So it follows, as a matter of course, that the lead department and the lead minister would be the Minister of Justice. It's just the way it is.
Technical point of
And
view,
then technical
it's
point
you
is the
who becomes
Director
the
General,
lead.
yes.
Yes.
Yeah, so the Director General facilitates at official level everything that's needed. So that's the role I played. Yes, and got everybody together, made sure that what was needed, they come with. So I talked to the other officials, make sure they bring the information and that they come where they were required. So all of that I did. So I was leader of the officials of government towards that particular
Okay.
process.
That would have led to what the minister will dispose of or deposit. Because you'd collate all this information, the minister will sign off what you are providing to the minister to deposit to the commission.
No, we'd give it to the state attorney and the legal representatives because they needed that to start drafting. Yes, so we'd give it to them, and then we started the process of drafting. So the draft, in other words, they indicate that this is how they propose. After taking instructions, this is how they propose to do the draft. As officials, is this correct? Is this not correct? Is this what happened? Is this what happened? And then they did it. Then they finished with the draft. Then they indicated that we will now leave with this draft and go and take further instructions around finalizing it. So the question was, is there anything else that is needed from the officials? And the answer was no, and this would be finalized. But I was in the process of, basically up to a draft, I was involved in that with the officials. We were involved, yes.
So the minister finalized alone without your advice as the accounting officer.
No, remember the advice is concerned to say we as the officials believe this is the best way these issues can be presented. Then the ministers and the president can then finalize however they want to finalize. But by the time the lawyers go, they've already taken our views and they've already indicated this is how this thing should be basically handled and submitted. So we would have made a contribution. So clearly I'm not passive in the way
No,
that
the issue
it was
is
suggested.
coming to, because maybe I understand, that's why I want to be clear, because maybe I would be operating differently as a minister, because there's nothing I would do without my Director General,
Yes,
nor my department.
yes.
Everything that I need them to give me a go-ahead, that this is accurate, this is, if they say no, I would not sign. So at this point, there's information going to the inquirer, the Khanyile inquirer. You are collating information. And I'm linking it to what Khanyile says is insufficient information and how you would be linked. Because you are delinking yourself to say, if there's insufficient information, that would be the executive authority, not me. But I'm arguing that the executive authority's ability to be able to submit sufficient information, it will be because of you. If there's no sufficient information, it's the Director General and the officials in the department. Unless if you are to say to me, no. At that time I was on leave, there was an acting Director General who then had to do this work. But if you were in office, that's your duty as a Director General.
Yeah. No, it didn't work the way you are describing it. Definitely putting together the information towards the draft, all the officials were involved. I was part of that process. The legal representatives they produce a draft, and we discuss it that this is what is going to go there. Does it reflect the views of the different departments? We all confirm that that is what it will review. For in relation to myself, these are the issues that concerned me, for argument's sake, and the others would do the same. Then the legal representatives would then say, we will now go and get further instructions on this issue, and we'll finalize this document, and then it will be signed off and submitted accordingly.
My argument, Advocate Shamila, is that your role, because you're advising the lead ministry, doesn't start and end with the department, because it's a submission that is overall. If the executive authority, that is the minister, it was not different ministers that were submitting. If it was different minister, I would understand. But here you have one minister who is submitting to the commission. then your role will be to include the department, but also to oversee overall as a counselor of the minister to ensure that what the minister submits is accurate and complete.
I'm not sure where we're missing each other, Minister, because what I'm saying is that the legal representatives on brief indicated that based on the terms of reference, the submission is just supposed to be a submission. So that submission was prepared and it was submitted. There was no issue there. We're all involved in that. I was involved in that in the draft. What I wasn't involved in was its finalization and sign-off, because that was done with the lawyers and the principals. But the draft that went to the principal to say, as officials, this is what we believe should be submitted, subject to the principals adding whatever they want to add. This is it. You know, that's basically what went. But when it went, it was at that time that these outstanding things that the other side needs to be attached. And what I'm submitting here is that then got done as part of the discovery process. So by the time the Khanyile hearings commenced on day one, everything that Dr. Khanyile says was not disclosed was already disclosed. Everybody had it. And in fact, the opinions were used in my cross-examination. The error.
Minister, thank you. Advocate Shamila, so you are saying the Khanyele's opinion was actually not about the content of what you had submitted, because the impression from my reading, when I was reading, it was almost like she is drawing an opinion on the content of what you submitted, not only the process. You're right. There was also the process, etc. But somewhere I thought it was also speaking to the correctness or the truthfulness of the content submitted by you.
No. Okay. Oh, sorry. Can I?
Yeah.
Oh,
I'm
okay.
done.
Sure.
Thanks.
Sorry. No, first thing, I didn't submit anything to anyone. That's the first thing. It was not my job. The legal representative on brief are the ones who are instructed to file. So the state's attorney filed the submission. That's the process of filing. You file through your lawyers, right? What is approved as client. Is that not so? And I wasn't client. Client was government as represented by the executive authority. DG was not client. So that was done, right? But after it was done, the other side then said, we await outstanding information for us to prepare. And that information was then provided. So the content that related to me was the opinions. The opinions were not discussed, but the issue was were they submitted. Khanyile does not say they were not disclosed. She says you did not take the advice off. And my argument is there is no legal obligation to take advice of a legal opinion, and especially when you disagree with. An opinion is an opinion.
I just wanted to paint a picture here as a political context of the time, because we might be dealing with this in an abstract. At this time, there is a move to remove the director, the National Director of Public Prosecution. It's a different process. It's a political context. Around the same time, there was a move to charge Xolisile,
Yes.
who was the co-chair in your justice cluster, right?
Correct.
So that these things are not seen in abstract. I just want to ask you rather directly, was there a time when NPA, even before you joined it, experienced undue political influence?
While I was DG.
No.
Oh, in
As
my
you
time.
observe from the beginning, and the times when you were DG and the time when you were inside, Was there a time, some have said state capture, some have called it different names. Was there a time when you would say there was this intensity to influence the NPA?
No. The only time it arose while I was DG was in the context of this minister letter, but other than that...
No, in your general observation.
No. Not.
So there was no time.
That
when
I personally
they-
observed, no.
You never observed
No.
anything? Okay, thank you, Chair.
Thank you, Chair. Advocate Simelaneis, I just want you to disabuse me of what I may have heard. I hope that I didn't hear you wrongly. You are saying this scenario has been lingering for long and you would want it closed out. For the past 18 years, it has been hanging on your, hanging as a cloud over you, and you would want it finalized. How should I understand you? Should I understand you to be saying that you would want this interviewing panel then to come to certain conclusions about processes which were undertaken, one by the Khanyile Commission, and then two by courts in whatever way that there are errors that you are actually then projecting out of the CC judgment? And then thirdly, the third leg of it becomes the JSA process, which you would be the first to accept that it is not for this committee, obviously, to deal with, including the other two legs that I'm referring to. Are you saying you would want somehow this interviewing panel then to come to a conclusion about those issues as you raise them? Is that how I should understand you? Just for my clarity, so that I do not then sit with a worry of what your expectations of this committee is.
Yeah, I think my expectations are clearly that, well, you don't have to find that Khanyile was wrong or what. What is important for me you do is that in relation to the issues you have to consider as a panel, to the extent that reliance by objectors is on what Khanyile said, you satisfy yourselves whether she was actually correct or not. So, for example, and that becomes important for me because if the objectors say the Constitutional Court said you are not fit and proper, all I'll say is simply look at paragraph 91 of the Constitutional Court judgment and note that as a panel we note that the Constitutional Court does not say Simelaneis is not fit and proper, because that's factual. That's factual. There's another example, because Khanyile said about 3 things or 4 things. In relation to the opinions, she said, you failed to follow advice, and she has a problem with it. This panel must note that a legal opinion does not bind a requester of it. You'd know that as a lawyer. It doesn't. So to the extent that an objector says, because Simelaneis did not follow the legal advice, don't consider him, you'd know that it can't be. That must be noted, that that's actually correct. 3, Khanyile says, these things, these documents, were not disclosed to my commission. They were not in the submission of government. I'm submitting to you that you should note as this panel that the things that Khanyile says were not submitted to her were actually discovered and were submitted as per her directions. So non-disclosure does not arise where a discovery process is carried out as required. Where is the non-disclosure?
Thanks for
That's
that
what
clarity.
I'm basically saying.
Minister, just 1 second. Thank you. No, just 1 second. I'm interested in how you summarize whatever. It's easy to go to a court judgment and say, this is not in the decision. Whatever is said obiter may as well has been said obiter, but this is not the reasons for the order or whatever that anybody can come to. And I'm raising this in context so that members of the public should be able to understand the responsibility of this committee in context and its duty as it is intended to advise the president on the suitability of any of the candidates that we would have interviewed on behalf of the president. Now, whatever conclusions that we may reach, in whatever context that we may reach them, it cannot be on the basis of our imagination of what we hope Khanyile should have said. What we can say to you is, this particular objector says the following. What is your answer? And you give us your answer as you understand it.
Yes.
And in our report, we would be able to say to the president, this is how we understood all the candidates. It cannot be, Advocate Shamila, that it becomes our job then to say the objector was wrong or right. That is not our point. We gave you an opportunity to answer to the objector, and that's why we're going to give you an opportunity again in front of everybody. I think as Prof. Fikeni is going to do towards the end, to say to you, objector X says the following about you. What's your comment? If you want to repeat it, you'd repeat it. But it cannot be that the expectation that you carry says that we must actually then make a finding of some kind that says our conclusion is, because that would be remiss of us, because that is not our duty. So we cannot be called upon to make a conclusion on an issue that we are not called upon to make a finding upon. So I just thought, let me and you clarify each other on that point so that we don't misunderstand you to be saying these issues that have been hanging are now going to find closure of some kind. But what should actually worry you, maybe in furtherance of your argument, should be the fact that if the JSA, sitting wherever they are, in whatever form that they have decided to proceed, whether you believe in their process or you don't, you are their member. And the way I understand it, from the fact that you are their member and they may have started a process which you know sits in another forum in court, it would not be correct of us to make any comments about it for as long as you agree with me that that matter then remains sub judice. So to that extent, it would then not be correct for us to say whether Khanyile, whether your submissions would have been complete or incomplete in whatever form at the time, because that was not our space, neither was it with our participation. So it cannot be expected from yourselves, at least of us, to say, reach the conclusions that you just summarized to me. And that's why I was asking you, is that your expectation? If it's your expectation, what do you base it on?
Yes, it is my expectation, and you're absolutely wrong. Your responsibility as the panel is to tell the president and advise the president that, President, we looked at the requirements of the legislation in terms of its requirements. We looked at the candidate, we looked at the objections, and the candidate gave us responses. Our assessment of the objections and the candidate's response, based on what he showed us, demonstrates that the candidate is either correct or wrong, in law or in fact. Not that you say that publicly, but the president is expecting you to advise me. What do you think of Advocate Shamila? What are you going to say? No, he's not fit and proper. On what basis? What are you going to tell him? That the objector had said this, and the president's going to say to you, what did he say? And you're going to tell him. Then the president's going to say to you, so what do you think? And what are you going to tell him?
That is fine.
Yes.
That is fine that you map it out. I'm saying I wanted us to be on one page of your expectation, because that's the part I didn't understand from you. So it's fine that you that's how you understand it, and as a panel we'll be able to decide on
No,
it.
that's fine.
Thanks.
No, that's fine, yeah.
Proceed.
Thank you, Chair. Advocate Simelane, I do hope that the pending litigation that is being pursued by the JSA does give you every opportunity to get the type of remedies you're seeking. What I'm curious about, though, is that in your papers you also concede that this has caused you reputational damage and has been something that's been carrying, kind of like a bit of baggage with you for almost 2 decades now. If you sort of, no doubt you've had a lot of time to think about it very deeply. I'm curious about what you might be thinking about, what you could have done differently. If you sort of go back and say, where could I have acted differently to either prevent or quickly remedy this thing so that I don't carry it for this long? I'm just curious about that. Any thoughts about any missteps or missed opportunities?
Well, first, there are no missed opportunities. So that's important to clarify. When you say remedy this thing, it's after the Khanyile report, what did you do?
It's open, either before the issue, after the report, after the Concord findings, after you went back to the bar and the matter started to come up, at the time that you're engaging with the GCB, at the conclusion of that conversation, just at any point, what are your thoughts about what you could have done differently?
There's nothing further to do, because I definitely engaged government to say this needs to be resolved, and there's correspondence to that effect, and that it to be attended to. So that was sorted out on that side, but nothing came of that process. So if nothing comes out of that process, there's very little I can do. So all I was then left with was, being in private practice, I then deal with the stuff that the JSA is dealing with, and that will be attended to in the normal course. But on the government side, there was no process set. And if you read the judgment correctly, judgment says that you can still be appointed, but before you are appointed by anybody, or by the president in this case, he would need to have addressed these issues as well. So that's what it means. So to the extent that this process goes forward, and assuming that, for example, my name is one of those that's taken forward, what Justice Yakub was saying in the Constitutional Court was that if anyone, the president in particular, is inclined to consider this name, he must then reflect on the issues that have been raised. And that is why I'm saying to the gentleman that is why the president would then ask this panel to say, to the extent that these 3-4 issues are raised and they were answered in front of you, what do you make of it? And that's where this panel would give a view.
Thank you, Minister. Advocate Simelane, you made a point earlier on the impact of the delays in processing this matter by JSA, that you've been sending correspondence to no avail. And you also made a point that there is prejudice that you would suffer, or that you are suffering, particularly where fit and proper is a peremptory requirement in certain positions that you may seek to, or which you may desire to apply. So is it then your view that the issue of fit and proper, which is a peremptory requirement for this position, would be a factor, as you made that point earlier?
Yes, the prejudice is not only in relation to this, it's in relation to everything else that's out there, as Ms. Manduleke indicated, it's reputational, right? Because there's an outstanding issue. But it fits in here, in that this panel can say, we'll put him forward as one of whatever number of names the panel puts forward. What I was submitting to the gentleman is that this then becomes current and present in this matter, because a deciding authority would then have to say, if I am to consider this individual, what do I make of these comments that were made in the Khanyile report? And the question would be, the purpose of this particular panel is to indicate that if we are inclined to do so, in respect of these comments that were made, this is our view, because we heard and saw what the objector said, and we got the response of the affected individual, and therefore this is our view. So I would expect that yourself or anybody who's a lawyer here would say, President, nobody is bound to follow a legal opinion, especially if they don't accept it. Standard.
Should we move from this now? From this? Just to get into the point where Advocate Simelane, you would have seen what is happening in the NPA as a person who's been there.
Yes.
Your vision of NPA. What would that be? How would we envision the NPA under your leadership?
Minister and panel members, the NPA is a unique institution because it comes from a history. You will never be able to understand the NPA properly if its history is not understood, simply because whatever is happening there today is partly a legacy issue. Most of the issues there are legacy issues, right? So my vision for the NPA is to assist the public servants there to not allow legacy issues to dominate their day-to-day work so that they're able to focus on their work. That would be the most important thing.
Explain that.
What I mean is the legacy issues, if I understood correctly, Advocate Cronje explained where the NPA comes from and how it's ended up here. I won't repeat that. The problem is, just like you have in any other government department, we have people from different backgrounds, from different histories, they have different histories, and they view things differently. And to that extent, many would want that which they are comfortable about based on what they know and what they understand best should be. So you have to unite the people around a common vision of what the purpose of the NPA is in modern day times, which is the NPA is rooted in the Constitution. It's a constitution that takes the country forward. You remind the people of the preamble to say whatever you may have done prior to that, to the establishment of the NPA, to the establishment of the institution, let that be. You focus now on what the Constitution says. You go forward and you do your work in that context. What does it mean? Then it means, if you understand the Constitution properly in terms of the values and so forth, I think that can be done. Your role in the country is to therefore ensure that you conduct your prosecutions and solve cases that are opened by taking them to courts and securing convictions. That's how the government of the day is fighting crime. That is your role as a prosecutor. Get the information, work on the information, take it to court, present it, take the criminal out of circulation, and move on. There are obviously many other different ways. That is the important thing to understand, because once that is understood, then people know why they are relevant, why they are important, why they need to do what they do on a day-to-day basis. So you need to nurture good lawyers in that sense, because as a NDPP, we are not really conducting prosecutions. We are providing leadership and a vision, and people must understand, why are we here? Where do we fit in the JCPS cluster? Where do we fit in the broader government? As the NDPP, you give that vision. You show them where they matter. So that's the first thing. So how do you do that? You've got to skill the officials concerned. They're already qualified lawyers, they already know how to run cases, but they're not skilled in everything that they need. Learning is a continuous improvement. Even lawyers in private practice continue to be trained on trial advocacy. It's something the NPA needs to do. Just because you repeat something over and over doesn't necessarily mean that you are up to date. From time to time, you need to meet your peers. From time to time, you need to be trained to upskill yourself. So those things will need to be done. That is the important thing. If that is done and they understood the vision, then the external factors of influence become diminished. They'll always be there, Minister, I can guarantee you, they'll always be there. But they become diminished because what you would have built is a character of individuals that understand their purpose and they understand what they're there to do, what they're there about. They understand what is expected of them by society as a contribution. Then they resist any attempt to make their work difficult, whatever way. In the strongest possible way, maybe subtle influences, but once they know what they are about, that gets avoided, right? So when you do that, what are you hoping to get at the end, going forward, looking back? You want to find a prosecutor that's compassionate, that knows that we're in the business of conducting prosecution of individuals that have committed a wrong. The Constitution requires us to still make sure that that is done in a dignified way, because those individuals have rights as in the Bill of Rights. So we must be compassionate to understand that although you are a serial killer, you're still human and we'll treat you with dignity. That's at least the minimum you deserve. Equally, they look at the victims and the survivors of crime. They must be compassionate to them, understand their expectations, understand that they expect to be treated in the manner that demonstrates that there's an understanding about how they feel about what has happened to them. So which means the burden that you place on an individual that we call a prosecutor is an enormous one. And in order for that individual to be able to perform those two conflicting tasks in a way, because that individual is complying with the Constitution, that individual must be appropriately skilled, trained, and assisted to function at that particular level so that they can carry that on their shoulders. So that is the vision. So when that is done, you then target the cases that need to be targeted in their various forms. I think the annual report demonstrates exactly what needs to be done, and there are many of them. As the NDPP, what one would have done with management, deputies and DPPs, would have had as a matter of course, because there's nothing new, everybody knows what they're doing, is sit and identify that at this point in time in 2025, what are the priorities that we need to focus on? There's a lot of cases, so there needs to be some prioritization, right? So clearly, as has been indicated in the public domain, there are cases that relate to certain activities, state of capture, the commissions, GBV, rape of minors, especially statutory rape of minors, rape of adults, as the case may be. And we start working on those cases and identify where we can make interventions. And I have some thoughts about that because these are targeted prosecutions in a way. My experience, and it's part of organized crime, but others may not see it as organized crime. Supply chain management is where, in many instances, organized crime begins. In other words, it starts small, and then it gets big. It starts small with three-coach system that gets abused. It grows according to number until it runs into billions. We tend to treat that as, it's a simply PFMA issue, fruitless and wasteful, irregular expenditure, blah, blah, blah. That's where organized crime actually begins. And I'll show you why I say that. How do you get a three-coach? You go to any annual report of any department or information and you ask them to show you all the payments that have been made just below 500,000. You get them in February or January, plenty of them, right? What does that tell you? Other than the fact that they may have been dumping. It means around that time, some individuals would have sat and have used a three-code system to just stay below the radar, 499,000, 450,000, 480,000. And they do that multiple times. And in some cases, upon further investigation, what you find that it's a small group of people, but they run multiple companies, but they use the same approach. It's easy because it's three codes. So in order to do that successfully, what do you need to do? You need to have somebody that calls for three codes in the department. Somebody who says, can I have a code from you? Can I have a code from you? Can I have a code from you? In some cases, people who do that, they call people they know that it's the same person, same people who have these companies, and they just deal with them. So supply chain is an organized crime business. It is not a PFMA offense. It's an organized crime. So that has to change in terms of how it's approached. And how you deal with it is, again, not very difficult. You know why? Every year, Ms. Manulege and the team produce reports in which they tell you where there's PFMA contraventions, or at least they're suspected. So all you have to do, if I were to be appointed, starting, let's say, March, there's 40 departments in the country, roundabouts. You take all their annual reports that were just published now in August. They contain all the information. And it's useful because they contain the information that has been prepared by experts. You look at it, you start investigating. Who do you need as your witnesses to come and say, this is what happened? You go to the AG and say, the auditors that worked on this report and produced it, they have all the information. They've analyzed it. They can talk to it. Can we have them as evidence leaders to come and lead evidence to demonstrate that this is how the contravention has happened?
Wouldn't that be a duplication with SIU's work?
No. In law enforcement,
Clarify that. That's what I'm asking, because
ma'am.
currently that's what they are referred to SIU. And I say this in the context where we are dealing with duplications, as you know. We're trying to rebuild and recorrect the infrastructure of the justice system, especially dealing with corruption.
Yeah. In my respectful view, when you present a case in court, 2 experts are better than 1, 3 experts are better than 1 to make a case. What the first one in this case would be needed for is that as the Auditor General with the stamp of approval of that office, that witness would say, we have done this work and this is what we have found, and I, as the auditor, I conclude that the following wrongs were done here by the following individuals, and these are my reasons for doing so. And they'll even go further and say, before I finalize my report as an auditor, we sent the draft, we sent a few comments, and we received management comments. We looked at them, analyzed them, attended to them, and we still conclude that on these ones, there's something wrong. That's valuable because what it does, you immediately put the other side to bring their own experts, similarly qualified, to disprove that. That's the first thing. The SIU will bring another expert. If the SIU had an auditor as an expert, that auditor may need not deal with the PFMA issues because the AG auditor would have done it. That auditor may deal with something else, financial information and other things. So there wouldn't be a duplication necessarily in that way. So that's how you split your experts in terms of the point to which they talk.
The issue why I'm raising duplication is because you spoke about if I'm NDPP, I'd bring the investigation. And my issue is that, but currently, that's what SIU investigate. I'm not saying NPA does not have a role, because currently as SIU, as AG does the reports, refers to SIU, SIU then does a further investigation and concludes, and then hands over those cases to NPA. And what I picked up was almost like a change of this process. Is that my correct understanding and reading of what you said?
No, unless I wasn't very clear. In my respectful view, there'll always be a difference between what the Auditor General stands for. Tactically and strategically, what you need in court for the Auditor General is the stamp of the office because it carries power. So if somebody is a credible witness from the AG's office, concludes in a way that is not refuted, that's a slam dunk case as far as PFMA contraventions are concerned and those criminal offences are concerned. That's done on its own. What the SIU side does, the SIU goes further and looks into other things. So that can relate to other charges. And in respect of those charges, they'll have their own expert witnesses to attend to whatever they need to attend to. And I believe this would even help in the sense that PFMA charges stand on their own. So if you want to create a culture of compliance, I would say let's just start with those. Even if you're investigating corruption as well, continue investigating it. But in the meantime, if we can prove fruitless and wasteful expenditure or irregular expenditure, we get it done and dusted, and we get a conviction. Even if it doesn't, in fact, I think it, depending on the amount, I suppose even if the amount is a little bit high, it may not necessarily require a custodial sentence. It's enough to get a suspended sentence. But what we got is a conviction. That's what matters. Because by the time you appear for corruption, fraud, and theft, you are already a convicted person, which helps in the context of sentencing, because you are then able to say to the presiding officer, this one was already previously convicted. And that changes the game altogether. And nobody wants to be taken to court to be charged and stands a chance of being convicted for the second time, because they know that sentencing gets worse if you're still within the suspended period. So that type of targeting of prosecution, in my respectful view, is important. But there's another side that is not always thought about. The BBEE Commission, where fronting is criminalized. I don't recall enough cases being looked at. Maybe it's because there isn't enough fronting. But I would imagine that where you have a body that conducts investigations of that work already, and they produce a report in which that body concludes that in this matter there is fronting, there's very little further investigation to be done by EDAC if it's EDAC or the DPCI if it's the DPCI, because experts in the field in that organization have already got the reports that says exactly what you need. You clean that up, you go and prosecute that, and you get the results. And the impact of it is that once you get a successful result on fronting, you deal with the systemic issue of fronting generally as a whole. And you assist small business to partner with people that truly value their skills as opposed to people that partner with them for purposes of renting their skin color. That is important of dealing with it. Thirdly, the Competition Commission amendments were made a couple of years ago where certain behavior was criminalized. Collusion, certain restrictive business practices, abuse of power. I don't remember a prosecution being run on the basis of a concluded investigation by the Competition Commission that abuse of power has been run. So the point I'm making is that we already do have bodies with qualified experts that do the actual work and produce the content that's required. But for some reason, we seem to be missing that. It may be that because of the volumes of other matters, it's an issue the NPA sees a little bit further down. But the impact of it is important. It's economic. It affects small businesses. Yes, it affects big businesses, but the biggest beneficiaries of success in that area are small businesses. The PFMA issues deal with governance and conduct within a department. You can even go further than and go to a municipality and go to an SOE, as the case may be. But if you just start in a department, you're done. In that you begin to create the culture that you need that changes conduct. If you change conduct in the department, the outsiders who are coming in to exercise influence start finding resistance, because these people here on the inside know that when our report comes out, there's going to be a bunch of guys that are going to look at the annual reports and start working on it, and we get implicated. It's that simple, amongst others. So for me, it is that.
Advocate Shamila, just
Yes,
a
ma'am.
second.
Thanks, Advocate Shamila. You earlier raised issue of skilled, trained, and targeted
Yes.
interventions. Now, I just want to know what additional skills. I hear you that from the respective areas of focus, there would have been foundational work and outcomes secured, or at least suggested, that would go to the courts. But inside the NPA, because throughout these 2 days, we've been hearing how there are limited skills. So what kind of skills would you bring, for example, for people to be able to take the AG report and go and prosecute on it and argue wrongfulness based on the information provided by the AG, or argue collusion based on the report provided by the Competition Commission?
Yeah. I think it's important to always not take only the version that says there's a shortage of skills. Someone must be able to say, what skill are you talking about?
That's
Yes,
my
I understand
question.
as a
Yeah.
question, but somebody who says there's no skills, they must tell you, what are you talking about? What skill do you say doesn't exist? Excuse me. But typically in the NPA, the most important skill must be the ability to present a case. So trial advocacy is important. And there's different levels of it. Basic, elementary, depending on the level of prosecutors. The more senior they are, the more experienced they are, the higher the advanced advocacy training requirement would be needed for them, firstly. Then there's also financial training, the ability to read financial documents. There are people, maybe us around the room, who may be qualified, but we may not be able to read a balance sheet. Give somebody a balance sheet, they don't know what it means and what it represents. And they may not be able to find a crime right in front of them because they just can't read a balance sheet. So part of the training would involve financial training, reading balance sheets, being able to understand things. Share price manipulations. Find somebody, for those that deal with a lot with fraud, commercial crimes, find people that provide specialized training to be able to identify share price manipulations where information is given. So in the NPA, we'll be able to look at the gaps. So when you look at the cases where there's successful convictions, others where they are withdrawn, others where they are struck off the roll, and they're going nowhere, it's important to sit and understand what's missing in what was withdrawn. Why was it struck off? What's missing? Fine if you can't find a witness, that must be found. But it can't be that we've got 5-10 arch-level files, we just don't understand them. We just don't understand them. What do you mean you don't understand them? Read them. We've read them, but we're not sure where the crime is. That could be an indication of a deficit in ability. And once that's identified and people are skilled accordingly, that gets done. To be able to find people that hide assets in trusts, in whatever other instruments that are utilized. And knowing that people actually do that, as many do in the public service. They declare and make it very clear that I'm clean, I don't have all of this. But a further check by those that are skilled and trained in that discovered that the bugger has an offshore account, that type of thing. So that type of identification of skills required starts with a painful exercise of going to look inside the organization, those that are struggling. Sometimes it's easy, you can go to court and witness it yourself, but based on the statistics that come out, and you start engaging with the DPPs to say, why is there prevalence of withdrawals in your case, or struck-offs, or lack of meeting the target as far as convictions are concerned, you'll then discover this. But my sense is that if you speak to people honestly, and they don't fear reprisal, punishment, and judgment, and that type of thing, people will tell you what they need. They say, okay, I think I can talk, but I can't write. So I need training on writing skills, because many arguments are won on paper based on how well it's written. You can be articulate, but if you've written badly, decision is already made. For other people, it's vice versa. You find that can't write to save their lives, but they can speak themselves out of any situation. Not one of those, but that definitely does happen. So you've got to look at those things, identify them, and skill them appropriately. Then you can even go overseas. It really just depends. And if you benchmark, you know what level people, somebody at the level of a director, you should know you should be skilled to this capacity. At a chief director, you should be skilled to this capacity. Entry level, the minimum is this. So that's important. Then if you target, you can go as far as you go in the sense that you can target really basic things that everybody speaks about, means sitters. Every year for the past, I don't know how many years, we're always talking about sitters there. So we may need to want to look at that to say, let there be a team that just focuses on sitter, and it depends on which one. Sitter as in the training authorities, but sitter the institution, the information technology institution. It's been a problem for people for years. All that I'm saying is that at the end of the day, it has implications for work. Is there sufficient human beings now to do the kind of work we're talking about? And I think there's a big risk in being all over and taking too much. One typical case that we can all identify with, but I wondered the other day if we think about it, the Meyiwa case. For how long has it been running? That long. It's one guy, Minister. It's one guy.
8 years.
No, however number of years, it's one guy running it.
Well, I'm saying 8 years.
8 years, yes, indeed. Advocate Balo has been running that case by himself for 8 years. He comes tomorrow, he says, I can't take it anymore, burn out. The case is not finished, it collapses. And yet it's 10 years late in the system. It delays further. So in all of this, with the menu of things government mandates the NPA to do, there's so many resources. So issue of resources would have to come in. So state of capture, then you add Madlanga Commission and all of those type of things, and the Madlanga Commission will have rollover of things. There is no way there cannot be a discussion about the number of human beings needed to come to attend to the problem. It has to happen. And once you bring them, you can bring them already skilled. They tend to be more expensive. You can mix, bring a few that are already skilled. They tend to move much faster. So they can do in a month what others would do in 6 months. So you need those. There's no doubt about it, even if you have to bring them in from outside. Find the money, attend to them. But you've got to build your triangle so that the bottom has a lot of people, pay them adequately. But you know that at least I'm going to lose 16 months because to train them to be able to be proficient can sometimes take that long. So you need a bit of patience. But it may start slow, but then going forward as they acquire the skill, they then move a little bit faster.
Are you?
So that really is the kind of vision. I could cover other areas that I think are important. One that I noticed that I found strange when we deal with corruption is, and I can't understand the choices that have been made and what it means. There's been a talk of amnesty for the past 2 years, 2.5 years, even more in the shadows.
Amnesty of?
Amnesty in corruption matters. There's a number
Where?
of people.
I've not heard it.
No, Minister, it's been a discussion going on. We'll
I'm
have to
in the
catch up
wrong
with that if
circles
need be.
then. They don't include me
No, not that
in
you're
those
the wrong circles.
discussions.
No, there are people that have thrown suggestions for quite a while to say the problem of corruption and state capture has been so big and so much money lost that what if there was a general amnesty in the country around corruption provided people brought in the proceeds? Is that palatable to society? Is that something society would be willing to consider? Those who are proponents of that approach suggest that we've gone just too far down the road. The only way out is to undertake that people won't have the negative consequences that they fear, but we'll get back a portion of what we lost, especially money, even if it's offshore, and we start afresh. It's that kind of approach.
Are we not having enough tools to be able to get that money, even if it's offshores? I thought that with the availability of the work that is being done by AFU, FIG, and others, we could, if we rather have the right people to drive that, instead of, because I know you are saying it's what is being discussed, and I'm exploring it because I'm hearing for the first time almost. Wouldn't that be seen as also encouraging corruption? Because I always say corruption is not a victimless crime.
Absolutely.
It's got victims.
Absolutely. Yeah.
And in our system, then what do we do with the victims of that corruption if we do the amnesty? I mean, you'd know we have a situation with the TRC Commission where the victims are saying there's no justice until people are prosecuted, they can believe that there's justice. Wouldn't we face something like that, as we think?
That's that's exactly the counter argument to it, to say, no, maybe hang on, that may not work very well. And I think that discussion hasn't sort of gained momentum, and I think slightly for that caution to say, what will it look like we are saying, to people? But it was definitely floated. A few individuals definitely floated it, seeking to influence the process. But the reason why I'm raising that is that there has been, and I think it's worth looking at, where in the NPA, one or two companies have come forward and returned money on the basis that there's a no-guilt arrangement, but also that they may not be prosecuted or need not be prosecuted. There's a problem with that. Because what is that? What framework is that? Personally, when I can't even remember the term used because I don't understand it. I've never heard of it. I know plea and sentence agreements, but I don't know this one where it says we'll have this kind of arrangement, bring it back and whatever. But there's merit in looking at what was attempted to be done. It may have merit and it may be explored further and it may be a solution, because the first prize is just taking that much longer and the menu keeps growing bigger and bigger and bigger. And if there's not enough resources to feed the system, bring in people and naturally technology to deal with these things, which is an inevitability, it needs to be done. If there isn't money for that, then there must be pragmatic interventions at some point about what we do where. So the NPA can play a role in that by indicating what it can do and what it is finding difficult to do and what it completely cannot do and what it needs to do. Similarly, it goes to the police and so forth. The problem that we'll experience with the two commissions that are prominent, that make it that much harder to look at the work, is that it's exciting to have a confession, to get told the truth by the confessor. The problem, can't use it. Can't use it. Come and confess and tell us everything you've done, gory, you name it, can't touch it. It's inadmissible. We still have to start afresh. I suspect that's why in some areas it's taking longer. So I would not blame the NPA, and I've defended it in various fora, that whilst there may be legitimate criticism in respect of the current NDPP's work, I think people are misunderstanding the difficulty of having to find some of the information while everyone is aware that that's the person they did it. The only reason they're standing there is because they confessed it. Otherwise, we know. So the NPA needs to come out and say, in respect of these cases that are standing still, the problem we have is basically this now. Because the frustration of the public is that with everything that we've heard, we don't understand why you can't move. It's because we can't use it, but also because we have to start afresh and dig it, which was always the issue with the SIU minister, in that they can conduct all investigations. You still need the DPCI to start and conduct an investigation. You still need EDAC to do that kind of work. So corporate prosecution side of the system doesn't look great. It does not look great. If you go to 2010 Stadia, there was deep collusion, deep corruption. A municipal manager dies for whistleblowing. What happened to those companies? What has happened to that case to date? It's 14, 15 years later. You move on to others accordingly. So those issues do matter, Minister, other than the usual cases that we all tend to talk about. In fact, here's something important that I thought I saw. A couple of months ago, I saw an article that said KZN last year had about 10,000 children giving birth under 16 or under 18. 10,000 children delivering children. I would have hoped that, and it's not only there, I think there are other jurisdictions, but the number, I thought KZN.
The highest is Eastern Cape and KZN.
Eastern Cape and
is the
KZN.
highest.
Yeah, I looked at this and I thought, the kids are delivered. Somebody should know who the father was. So depending on age, I suppose the younger they are, they may be unable to identify the culprits as quickly as possible. But I'm imagining 13, 14, 15-year-old can say it's so and so. That becomes a person of interest, at least at a minimum. Without exposing the identity of that person, the person gets engaged to say, this is what we have, submit yourself to a DNA. Nice, quiet. We don't have to besmirch your name in case it goes wrong. You work with that environment. It's managed quietly. You get the DNA. If it's not the person, it was quiet, the person was never exposed. It must be handled sensitive. But if it's the person, you've got your culprit. I don't know how long forensics takes these days. But
Is there a quiet process?
no, there is, Minister.
Because I deal with litigation of the state, as you know.
Yeah.
False accusation and all those things, whereby the minute you say a person, then they say no. I had to explain to my wife and my family why I'm going here. I was asked, and therefore there's implication, and legally that person can take us to court.
Well, either way, whether you do it quietly or not quietly, you'll end up with that scenario anyway. But what I'm trying to suggest is that...
That's what I'm saying. Why quietly?
Well, in the sense that you may find people that don't want their name associated with that. To come and sue later doesn't sort you out, Minister. You can say, look, I was wrongly accused, I sued, I got 300,000, so you're still the guy that, once the damage is done, you can't fix with money. We're not like America where at least you get millions. You can go hide in an island. Here in South Africa, you get 50,000, and the best you can get with that is what? Tickets to a suite.
Okay. I would like to move to the next segment.
Yes.
Because I think we've gone in detail in terms of what you see as the work that needs to be done. And I want to open for the panel in terms of their questions, and then end with Prof. Somadoda Fikeni with taking you through the comments. Just to check the side, any other question? Okay, from here. You've got Advocate.
Yes,
Proceed.
Minister, it's just a small one. I would like to know your opinion on laboratories, because forensic laboratories are the biggest hold-up for and whilst you are there, also maybe just club to Xela care centers there. We've got 66 of them now, and no very limited funding from government. Just briefly.
Yeah.
Sorry, Minister,
Yeah.
I'm taking time asking.
But DNA is the responsibility of police, but we do work with that, but it can go on.
Okay, all right.
Yeah.
No, I can withdraw it. It's just that I think.
You can give an opinion.
Okay.
That issue's been there for a very long time. Now, how many labs must you basically have? Ideally, a dreamer would say a province, there must be one, at least a province, to focus on those statistics, But others would give you better to say you don't need 9, you may do well with 5 or 6. We don't know what the holdup is. The police will explain. It may be an issue of resources, but there must be a way in which that is identified. It's either it's money to have them and equip them, or if the money is there, it's finding the people and having them appropriately trained to deliver. But there must be an answer of some sort. It can't be an issue that gets discussed all the time, because the numbers we've discussed about these kids, those are the victims the minister is talking about. It's 10,000 victims waiting for justice. And if you deal with 1,000 of them successfully, the other 9,000, you can't. Then they go back to school. Whatever the numbers may be in each province, that's a problem. So that's the first thing. Xela care centers, I suppose, will always be a money problem, in the sense that to create it, it's a model that is great, that's excellent, it works very well if it's functioning properly. It delivers. But it's a luxury right now, because in terms of the numbers they deal with, they are a pittance compared to other numbers out there. They remain not as accessible as they can be, as they should be. And the only hold up is money. And somebody else would say, if you sorted out the labs, you can get more numbers done than in a Thuthuzela care center. But the problem is that a Thuthuzela care center is advantageous because you have more of a skill set and you have an approach that manages issues in the best way possible. So money, yes, is a problem. Thank you, Minister.
You can proceed.
Thank you. A quick question. So what are the top 3 things that diminish public trust in the NPA?
3, first one is not knowing what they do. Just have no clue what they do.
Huh?
Well, not me, I know what they do, but I'm saying the public doesn't know what they do.
Oh, okay. I thought you were saying NPA colleagues themselves don't know what they are doing, Advocate Shamila. I was like, you.
No. No, those ones know very well. They know very well what they're doing. I think the first problem is the public just doesn't know what you do. How do you make decisions? The choices that you've made, how do you make these choices? Choosing this one and that one. So 2, it's the lack of transparency. Decisions tend to be made quietly in a closed group, collegiality. That's just a issue of habit. We need to be more transparent and be more engaging. When the NPA communicates, it doesn't communicate the detail that it needs to communicate that builds confidence. And that may need to change. Yes, it's important to let people know that the case came to court and left and the matter is postponed or withdrawn, whatever the case may be. Maybe a little bit more. A little bit more explain why is the matter postponed for 6 months, because that's the next date, purely on the basis that for some reason somebody could not arrange a foreign language interpreter. How did that happen? We're losing 6 months because an interpreter couldn't be found. And yet when the matter was postponed to that date, those involved knew that when that date comes, an interpreter, foreign language, would be needed. So why is it that when the matter comes, the issue of a foreign language interpreter, was it deliberate to create a further delay? Or something fell between the cracks? Are there no partnerships? In my time with Justice, we had an MOU with Pansal to say, can they build capacity to be able to provide different foreign language skilled individuals that the department could borrow from if they were needed in court, as the case may be. So those things, they're not soft, because I know people tend to say communication is soft. It's actually very strategic and very key. So I won't use the word soft, but for me, those are the most important. When people get to court, ma'am, they come to court, they hear the matter is postponed, and they loiter. You can see that they have no clue what just happened, unless somebody goes to them and sits down with them and takes them through. It's postponed for this reason, especially in cases involving violent crime, let alone rape and sexual assaults or GBV, as the case may be. So that becomes very important.
Anyone from the 2 colleagues? Fine. Prof, I hand over to you for the segment of public comments.
Well, thank you very much. 4 hours later, we're almost there. This last part, Chairperson and colleagues, the nice thing is that we front-loaded those, because it's mainly your comments received from 28 organizations and individuals, mainly individuals, then 2, which I should start with, were in support. One being the Deputy Secretary of NAHAU within the Department of Justice, and even saying that he wishes that you had to come back as a DG. Then you also had another individual who indicated that you have depth, experience, resilience, and institutional knowledge that you'd bring. But then the balance of the comments have generally been objecting.
Yeah.
And in the objections, they referred to the Ginwala observations on your character and integrity. The issue of integrity keeps coming again and again. Some implicates you in the role of capture, state capture. Of course, they tend to put it in broad terms at times. And of course, the media generally had raised those issues as well. And they often cite the Constitutional Court. Some, of course, saying that Constitutional Court finding against you, but others accurately saying that it was on the President having failed to look at the Ginwala and take that into account as you were being considered. Then we had one from a former NPA member who indicated that he's now retired but objects and go on, you must have received the documents on the specifics where he's objecting as to why and what conduct there was when you were there. But the bulk of them, which is something that I would like you taking others, of course, into account because you were given a chance to respond to them. You gave a very extensive response. Most of them talks to a very fragile NPA that is struggling to reposition itself. Then they say you have these many pending cases, unresolved issues, which by your own submission and presentation you have also indicated. They say almost this would squeeze the very oxygen from an entity that's trying to rise should anything happen on the pending cases. What would be your reflection to that? Because in essence they say in a hypothetical situation you were considered, you have to deal with these pending matters unresolved, and this forum, as it was indicated, can't resolve those. And then there's NPA that also is facing major hurdles that it has to deal with as a repositioned organization. How would you deal with that recurring concern? One, integrity. The other one, the one of the reputation and the reputational risk.
Well, I think thank you. I've demonstrated to yourselves instances where that submission has no merit in relation to Ginwala, just basic at a common level. Non-disclosure is a non-issue because there was disclosure in the way that legally it's accepted. Discovery process, it's done. So that takes care of two things. It takes care of the letter. It takes care of all the other attachments. Opinions, no obligation to follow them. That takes care of that. Accounting officer issues. The head of department is responsible for the relevant issues, as accounting officer is responsible for the finances. And the issues that Dr. Ginwala was relating to are issues relating to the responsibilities of the DG. Those three fall away. So there's no merit as far as that is concerned. So this shouldn't recur. Whilst this panel doesn't have to make anything public, what I'm trusting it will do is to advise the President properly. The issue that is sub judice is the one that remains outstanding. Can I respond to the issue of the arms deal that I was informed? I don't know what Advocate Cronje
Before you
said.
move that one, you're saying which one is sub judice?
The JSA one.
The JSA one
Yes,
was
it's in
first,
court.
just to be clear, first they found you guilty,
they
and then
did
you
find-
appeal.
Yes, there's an appeal, yeah.
So there is an appeal, but they have already had one. I wanted you to deal with that because it wasn't clear that it
Yeah, they
was
didn't
as
deal
if
with the appeal at all.
they haven't.
So what they
yet.
did instead, they just moved. So the appeal remains outstanding, and while it's outstanding, they just move for a strike-off. So the issues before court are sub judice in the sense that they will address these types of issues, whether
Okay.
what they've proposed to do, they'll do.
No, I wanted to be clear.
No, absolutely. The issue of the preservation order, can I deal with it because it was suggested? And I'll deal with one or two other cases. She's correct that that got done, Minister. We did that. No, that got done, Minister, and it was done legally so. And I would have expected by now that if anybody felt that anything unlawful was done, they'd have gone to courts to challenge it. What had happened again there, we have two things. We have the arms deal criminal investigations that were going on the side, no problem there. Those continued, they're not the issue here. But the individual was also subjects of those criminal investigations. But then there was a preservation order on a bank account that he held in Switzerland. That's what the preservation account, order was, on the basis that it's unexplained income. Nobody knows where it's coming from, so we're holding it. So his legal representatives, Advocate Celias, SC, and them wrote to the NDPP to say, there's a preservation order and we're making representations, and we argue that there's no basis. And they submitted documents to that effect, and they asked for, again, a meeting to have that discussion. So the documents came in advance. Arch-Lava filed about 2 of them or so. I looked at them, and I said, okay, the meeting can take place. But I then asked the head of the FU, Mr. Hofmeyer, that we discuss this, which we did, and we agreed that we would meet Mr. Silas. They would bring the team with. Advocate Cronje wasn't there. So if she said anything here, it's obviously hearsay. But I don't disagree with it because it virtually did happen anyway. So we had a meeting, and the legal representatives came, and the team sat like this in a boardroom and received a presentation. And
This team involves as well the head of FIU.
AFU, yes, yes, it was there.
AFU, which was leading.
Yes, it was
this
leading. It was
matter.
me, it
Okay.
was him.
And
I
then
think
from the
it was another
province that
deputy.
was dealing with it?
It was
Well,
Gauteng. It was this one.
It was
Yeah,
Gauteng.
it was this one. So it was an HQ matter. So, and then they called other prosecutors who were dealing with the broader arms deal criminal investigation just to be present. So it wasn't an issue. So they were all there, close to 10, 15 people in a room. So they came, and then they gave a presentation why they believe that the preservation order should not be taken further to a forfeiture order, because that was the next step that was gonna come. So the official said, well, we haven't seen some of these documents. We need an opportunity to look at them. So I said, look, thank you for the presentation. Leave these documents. We'll discuss them internally, and then you'll be advised accordingly what the attitude is. That was done, and then I took those documents and I said to the colleagues, I'm going to make my own copy, and I'm going to send these documents to everybody else for everybody to have their own copy. Then we'll meet to discuss. The following week, we convened. Everybody had read, we sat, and we had a discussion. What is the issue here? The issue is we don't know where this money is coming from. Okay, how far is the investigation going? Investigation is going. The preservation order is going to come to, is going to reach its time frame. Preservation order is a couple of days, I think 90 days or so. And if you don't extend it, it lapses, that kind of thing. So we started having a discussion about this thing. And I said, let's all discuss, because I must respond to this. So let's all discuss to finality. Everybody's at time. Let's now comment. We went back and forth, back and forth, back and forth, back and forth, back and forth. And every time we went back and forth, we kept looking at the document submitted. Then the numbers started changing. You know, it was a majority, no, let's extend it. Minority, no. Then started moving. Then I asked the number of those that were advocating for preservation order to be extended, and others were saying, let it lapse or withdraw it, whichever one you want to do, it's your decision. because they were not so sure anymore, right? There's a lot of information. Then in the documents, I drew their attention to a contract that was there. Said, as everybody looked at the contract, and others said, yeah, we've looked at it and all that stuff. I said, what do you think of this contract? I said, yeah, it's a contract between this individual and these other parties. Okay, I mean, have you read what it says?
What's the parties in the arms deal?
Yeah, well, in respect of just these two parties, the individual whose account was blocked, and another party, they had their own agreement. Yes, it's part of the arms deal. They are in this agreement. So in this contract, they agreed on certain services. So that's fine. It's not an issue. But in there, and nobody had an issue with those things. So we say, so what does it represent that there's a contract? Is it legally binding? Is there anyone with evidence that this contract is not legally binding, it's been set aside or whatever? Because as it is, it's legally binding. We debated that. The conclusion was it's legally binding. So, okay, it's legally binding. So what does it mean? We look at it, say, well, it's legally binding. Then somebody said, yeah, the amounts involved, they were not indicated in the contract, but a commission was indicated. I said, okay, there's a commission there, okay. So it looks like the monies came from this, based on this contract, which is what the parties had submitted in their submissions, that it's this contract, the basis on which the commission was paid and the parties were paid. So is there anybody here that would say it's unexplained income? So nobody could. Everybody accepted that. No, that explains it. So if it explains it, is there a basis to hang on to the preservation order? Because it's been explained. What do we do? This is what the parties have said. How do we respond to this? Well, you can't explain. So the long and short, the conclusion was, well, because the matter of the corruption on its own is still being investigated and there's no conclusions and there's no link to this particular individual, we can't say that this individual is still part of or is part of that corruption investigation, but that this individual has given an explanation which, on the face of the documents provided, there's no counter-argument that we can rely on. On that basis, I then indicated that, well, if that's the case, it looks like it's going to be very difficult to extend the preservation order. It may very well be withdrawn, and that's how it was withdrawn.
It was a team agreement.
It wasn't a team agreement. Basically, they said it wasn't an agreement, a team agreement. They said, we understand, we see it, but it's your decision as NDPP. Then I said, I have no legal basis to argue if I don't have information.
I'd taken over from Prof. My apologies.
I'm not going to start anything new. It's just the completeness of record to say that the Labour Federation, COSATU, also objected, and the Freedom Under Law also objected. Active Citizens Movement also objected in addition to that. And also another part is that the Public Service Commission has also been used as a reference point for the findings. But in this case, it can't be your fault because they were asking the executive authority to take an action against you. And if the executive authority didn't at the time, so it is just the list of things that they were referring to, all arising from the Khanyile matter and things of that time. It's just for those following the proceedings. Minister, thank you.
Thank you, Minister. On the Public Service Commission, if I can close that loop, it's not entirely complete, Prof, because the Public Service Commission, the problem with that investigation is that they also never spoke to me. It did what they called a desktop investigation without speaking to me, and then by the time it was produced, they had a problem because I was not given Audi, and that's how that matter ended.
And did you challenge the report at any stage because of that flaw?
Of the Public Service Commission? No, I didn't challenge it, no.
Just something from my side, Advocate Shamila. On your response to us dated the 8th December, there's an issue that you flagged there in relation to Eugene Terra Blanche murder.
Yes.
You said.
On the 8th of December.
Do you have the copy?
Yes, I have a copy of the document. I remember the terre blanche
Yeah.
matter, yes.
This one you are responding to, I think you are responding to a comment. But I do find something in it that I wanted to talk to you about.
Yes, paragraph 5.
Paragraph 5.
Yes.
In there, you talk about, as the NDPP, identifying a prosecutor in the DPP's office in Pretoria who'd attend on the bail, but also yourself as NDPP, traveling to Ventersdorp and personally meeting the families of the deceased with the prosecutor, but also in terms of an African minister, I think here, who had instructed to speak to the family in Afrikaans, and also the language, you highlighting that he did, and the family. I also addressed members of the AWB who had gathered outside to protest.
Yes.
I go back. Where is your DPP at this point?
Oh, no, he was there. He was part of the decision. He actually is the one who indicated the best person to do it.
He indicated?
He indicated the best person who would do it. The issue was, when we're in a meeting, when we're discussing the case, and the issue was, how are we going to approach what was likely anticipated would happen there in terms of protest and so forth, right? And the suggestion, even from the DPP, was that, can you as the NDPP go and assist so that we can quell whatever volatility that may have been there? Then I said, no, that's fine, I'll be happy to go. But I don't speak the language. Do we have people here that speak the language? And he indicated the officials, and one of them happened to be African. Then I said, okay, why don't we use this one? You know. So he said, no, actually, this is the perfect one that you can take. Why don't you go together? So he assigned that particular individual. It was the
DPP in Northwest.
No, not Northwest, here
Gauteng.
in Gauteng.
And where is your DPP prosecution?
He was around. He was around. I think it may even been him, but definitely was around. Yes.
This intrigued me, and you'd remember previous as well.
Yeah.
You spoke about the police and how the hierarchy works in NPA.
Yeah.
So as I look at the comments, I think I missed it. I would have raised it earlier on.
Oh,
as I
yes.
look at the comments and your response now, I'm picking this up because it does concern me.
Yeah.
That you seem to have been too involved in prosecution and also jumping over almost other, because you had a DPP, you had a DPP. The DPP says, no, come, NDPP, and deal with the court matter.
Yes. No, I think you have it wrong, Minister. Yeah, it's the NDPP.
Help me understand it properly.
In this, the NDPP doesn't deal with prosecution decisions. There's no need, but the NDPP is present.
I want to understand your role here. What were you doing?
No, it's
Because
just to
you
be
didn't
around.
explain.
No, it was for the NDPP to be around and deal with third parties, those who are protesting, and to assist the prosecutor by just being present and calming everybody down. The issue is, it's almost like the Northern Cape one.
It was more support.
Yeah, it's more support. You do nothing. You just go and support.
No, that's why I'm asking, because you didn't specify.
Oh, yes.
And then it almost looks like you are the one who was going to court.
No.
To deal with the matter.
No, the only matter where I went to court myself was in the Northern Cape.
What was happening there?
Yes, I deal with it in paragraph. Same document, I deal with it in. Is it this paragraph? Okay, it's not in this document, but it's one of the cases I explained.
I didn't pick that up.
The document on dated 20.
Do you pick that up? On which deck? Paragraph 4. Yeah, it just says it is common cause that I'm the only NDPP ever to have roped and moved a case in a court.
Oh, I don't deal with it in
Oh,
detail.
I didn't
Oh.
even, is, yeah, I
I
didn't.
can't remember where I may have put it then. But I did submit it. I did submit it.
That's the only sentence.
No, I did submit it.
No, it's this one.
I did submit it. I can't find it now. But effectively, no, I did.
Paragraph 3. In the start of the prosecution of the chairperson of the NC, Mr. John Block. In this case, I
Yes.
personally roped and moved the bail
Yes,
application
it's in paragraph
on
3.
behalf of MPA
Yes. There
and
was-
attended the bail appeal in the High Court.
Yes. It's the only time where I specifically roped at the request of the Northern Cape team. No, they were all there, but they were fearful. The situation was problematic from a security standpoint. And over time, the DPP requested that I come and assist the team. Because Northern Cape was small and everybody knew everybody, the prosecutors didn't want to go because they feared being identified. So I brought a team from KZN to go with me, to go and move the application. And I then moved that application.
I think it's late at night as well. You'd understand my discomfort where I'm sitting.
Yeah, I'm sure to be explained to you.
Because when we say, let me come to this point. I have an issue if we would say that NPA would have a DPP, would have prosecutors that operates with fear. And it will have to take an NDPP to have to go into a court, because when there's a review to be brought in, you've nullified yourself. I don't know the legal language they will have. I don't pretend to be a lawyer. So I specialize in my own areas, and that's why I would go into the areas. But in understanding the policies and the role of the NDPP,
Yes.
you could have easily compromised that case, because if the review is to be brought, where do they go?
The review of what?
Of that case. Let's say there's a
It's in court.
representation.
It's reviewed in court.
There's a representation to the DPP. DPP decides yes, and you think then it's brought to you to be reviewed. Because the fact that the person is charged at bail doesn't mean that the case is done. It can still be, there can be a request for representation.
Yes, a bail is not a trial, Minister. They
Yes.
can still be, no, you're not functus officio on that basis. Bail proceedings are completely separate from criminal proceedings, like trial proceedings. It shouldn't apply there. They could still review or make representation. Sorry, if that's what you mean, because they'll be making review on the merits. Bail is a separate sui generis.
So you only got involved at a bail.
Only the bail.
And then what happened? Their fear of crime, what happened? It diminished. Then they carried to the case.
Yes, they did after a while. Well, there was a broader intervention.
Remember, I'm coming with your logic.
Yes.
That I went there because they said it's a small province. We will know each other. Therefore, there was no one I could send except myself as a leader. Go take it, and I move the bail. But then I'm asking about this because I'm assuming from where I'm sitting that the fact that these people were scared, it means You would have had to take the responsibility. Now you are saying, no, I didn't take the responsibility of the case. I moved out.
Yes.
Now I'm asking, at the time you moved out, the same team took the case further.
Yes, there were other arrangements that were made around security to diminish that, because the matter was reported to the police, and the police had to intervene and create an environment where, going forward, that to be diminished.
Okay, so we
Yes.
couldn't do that at the beginning.
No, it initially couldn't be done.
Why not?
Well, that's what the DPP indicated to me, that they've tried everything. They requested, just as a start of this thing, can they be assisted on that basis?
But why didn't you do that instead of you going to the case? Having experience in the justice cluster, the network that you'd have had, being former DG, obviously you would understand, you'd know who to reach out to be able to do that. Why was that not done instead of you going to court?
No, it was still done, even for everyone, including myself. That was done, Minister. It was decided as the prosecution that let's do it this way in order to attend to the threats and in order to attend to just the fact that we need to get started one way or the other. So to get started, right now, those prosecutors and the DPP couldn't do it. For example, I'd ask the DPP, but what would be a problem if you did it? I could come and support. They wouldn't have it. So after a lot of discussions, the conclusion was, just help us get over this line, and then going forward, we'll see how it gets managed. And that's how the intervention continued over a period of time.
Mr. Mtlou, and then...
Thanks, Minister. Maybe this miscomprehension of the facts as you presented them. My impression was that you actually attended to that matter. You appeared.
Yes.
You appeared. Now, the issue of having now compromised yourself in as far as in the event that there would be further review processes, representations that are to be submitted to your office, you would have rendered yourself unavailable to attend to that, in that you would be functus officio in that space.
No.
Because you would have had intimate knowledge of the matter.
No.
You would have dealt with the matter at bail stage.
No. It's a bail application.
Yes.
Mr. Mtlou.
Yes.
As you know, a bail application is still a matter pending for investigation. And all that is being decided in a bail application are bail-related issues, only that and nothing else. It doesn't deal with the view on the merits.
That's actually not really cast in stone. You could have a situation, unless you're saying in that specific matter, merits were not dealt with. But it's not cast in stone that in bail proceedings, you would not necessarily get into the merits.
No, in this case, it was purely about whether there is bail, and if there is bail, to what amount.
Okay.
Yes, thank you. I just want to check if this process of your intervention in the Northern Cape was formal in a sense of correspondences, documentation, and so forth that is there, or it was communications, one phone call here and there before you entered the space. But also, if you can, for the purpose of this context, indicate whose case was this and why had it become such a big deal?
Yes, there were formal meetings that took place. The reason why there were also formal meetings is because the subjects of the investigation in KZN were also in the Northern Cape. That's why it was easy. It was basically the same case, but in two provinces in terms of the individuals involved. So there were multiple teams meeting, not teams as in like physical meetings, that took place to discuss what should be done. I'd gone to Northern Cape earlier before this particular date, and the team that side had come to Pretoria a couple of times, and that also met with the KZN team. So there is a formality to it. The DPP in Limpopo will confirm it because she's since been transferred there from what I understand. What was the other part, Prof?
Just for the sake of this, who was involved in this case? Why would it become such a big deal so that people following this case don't think that a small village, ward councillor was involved, therefore people start fearing everything? Why was it a big deal?
No, I think the difficulty is that one of the individuals being charged was the chairperson of the ANC in the Northern Cape. That was the difficulty, and there'd been mobilization to support him as there was. So that was the concern.
Okay. Thank you very much, Advocate Shamila. I'm happy to announce that we have come to the end of this interaction. And thank you very much for making time to interact with us.
Thank you very much. Appreciate
and
it.
making yourself available.
Thank you very much. Thank you.
And have a lovely evening.
Thank you, you too. You too. Thank you.
When you appointed as the NDPP, would you go back and say, you didn't want to work with me, therefore you're going? Or there'll be chaos, catastrophe?
Yes.
Just explain that so that
Yeah.
we all don't take it in a context that you don't mean. So be
Yes.
specific about it so that we are clear
Yeah.
from that word. Sorry, Prof, to come in because I just picked up that word and it worried me.
I think that's very fair. I did, when I left the NPA, I didn't really have an opportunity to explain why I was leaving. A press conference was held and things were said. I'm very outspoken and I did wish I had an opportunity, but I also felt that I was so emotional at the time. I was so intensely raw that I was concerned about what I would say. Like many people are worried when I speak. What is she going to say next? So I thought, I needed time to reflect. I needed time to think about what happened in that experience because